plain, my lord. While in the scrutiny, my lord, we have removed all the defects. One small mistake, my lord, in the statement of truth. I am not taking leave, my lord, to correct it in the statement of truth, my lord. One small mistake, my lord, in paragraph 4. It should be page paragraph 23. The plaint has been sent by department here.
Okay, let it come tomorrow. Monday has to be mentioned. I will.
As your lordship, please.
Lordship, may I have your lordship's leave to mention a testamentary matter which is appearing in your lordship's list today as item number 42. Your lordship will recollect this is that matter where the
Argument.
argument stage.
Will.
Yes, ma'am. Well, the proponent is very terminally ill, my lord. The lordship will
Item number?
recollect.
Item number 42. Who is for the other side?
I am mentioning notice, my lord.
You do one thing. Can you come at 2 or your junior can come to the other side today? Because originals of this non-commercial matter will be taken at 2.
I'll come.
May I have a lordship kindly to mention item number 22 of the 2 p.m. list, non-commercial. Your lordship, this matter has probably been mistakenly parted because.
Okay, whatever the non-commercial matter, come at 2. Mention, I will see to that.
My lord, I mention, my lord, may I have a leave to draw and complete your lordship order?
Which order?
Order dated
Date?
20th June, my lord, 2025.
My lord, may I mention item number 24 today, commercial matter.
24 of commercial list?
Commercial execution.
Yes.
So I want that it may be proceed or after 2-3 days. I want this to be adjourned for 2-3 days, 23rd or 22nd.
Why?
My client is not here. He has gone out of our.
Okay, you are for the you are for the decree holder. Let's see what about the judgment after, whether a notice is served or not. Let us see.
This is the first only fresh case.
Press 1.
Yes.
25, 20?
24.
24. Record an order as per the prayer. Item number 24. As per the prayer made by the counsel for the decree holder, case is adjourned. Let the matter appear on 29th.
20.
Come on, 29th.
Lordship, with your kind leave, I am mentioning a matter. Lordship, this was a order passed by my lord granting probate to my client. Lordship, there's one difficulty we are facing with the department for the final probate. In the death certificate, the death certificate was in Hindi. It was translated in English, and instead of Virendranath Moitro, it has been recorded as Virendranath Moikhya. So the department is not accepting the document, lordship, and is not issuing the final probate because of this small name error, lordship. So this has to be corrected because otherwise everything else is complete, my lord. I am unable to draw up the probate because of this. If my lord may see the third line, lordship, Virendranath, it is Moitro, and it has come up in the English translation as Moikhya. So that error needs to be rectified, lordship. The department has said either we take a fresh death certificate from the department or we take leave of court. Lordship, it's a 2003 document. It will not be possible for us to obtain it from the department at the
But
moment.
now this court is not having the determination.
Lordship, this is my lord's order, so my lord has the power to issue a clarification or a leave.
So you, what in the publication, what name you have made?
Moitra, lordship. It has
Moitra.
been Moitra all along. I have all my documents reflect Moitra.
Then you have to come with an application.
Lordship, I may do that as my lord may plead.
An
I may
application.
proceed. I may file an
Come with an
application, lordship. I'll do that. Grateful, lordship.
Yes.
You only have a plaintiff.
Sorry, dismiss. Suit is placed in the list of the undependent suit. Grateful.
Grateful.
I appear for the petitioner.
Yes.
Lordship, I appear for the respondents. I am being led by Mr. Sudipta Sarkar and Mr. Krishnaraj Thakkar. Both will be shortly here. Will Lordship grant a short passover?
Well, I can start with the
Let us
matter. It
start.
takes some time.
Mr. Sarkar is here.
Yes. Well, may I file the affidavit of service? Well, before your lordship opens the paper, well, the plaintiff number one, is a creditor, is a security furnisher for the plaintiff number two. The plaintiff number two has borrowed certain monies from the defendant number one. Well, the net result is plaintiff number two has borrowed certain monies from the defendant number one. Plaintiff number one has, amongst others, furnished security, including by way of pledge and mortgage. Now, the loan agreement provided for payment in tranches. It also provided that if payment is not made within the time provided, then there's a default provision for which interest at penal rates will have to be paid. Now, the first two installments were paid on time. The third installment of about 12.75 crores, that fell due in May. There was a delay in payment. Because there was a delay in payment, they issued a notice recalling the entire loan, which could not have been done because of the provisions in the contract itself. Thereafter, I made payment of the entire defaulted amount. Notwithstanding that, the threat that is now being issued is to proceed against my securities, mortgage properties, pledge properties, etc. The next installment has fallen due. I have made part payment of the next installment. I cannot pay the balance of the next installment because now the demand is for payment of the entire sum. The question is whether my learned friends can now give effect to the default notices because today, otherwise the entire thing will come crashing down.
What is the default notice?
The default notice has been satisfied. Entire amount in default has been paid. But they continue to persist with their contention that the entire amount under the loan agreement has fallen due. Now, may I just show your lordship the loan agreement once? The loan agreement your lordship will find at page 156. Volume 2, page 156. This is the loan agreement between the parties. I do not want to trouble your lordship, with all the terms, but please straight away come to clause 2.3 at page 159. (159), 2.3. If the borrower defaults payment of the outstanding amounts on its due date, interest shall accrue on the unpaid sum from the due date up to the date of actual payment at the rates as specified in Schedule 2 hereunder. The default interest accruing under clause 2.3.1 shall be immediately payable by the borrower on demand by the lender. Default interest, if unpaid, arising on an unpaid sum will be compounded with the unpaid sum at the end of each interest period applicable to that unpaid sum, but will remain immediately due and payable. The borrower hereby expressly acknowledges that the further rates of interest in clause 2 are reasonable and that they represent genuine pre-estimate of the losses expected to be incurred by the lender in the event of non-payment of any monies by the borrower. What the agreement therefore clearly contemplates is there may be a default, but so far as the default is concerned, you can ultimately cure the default by paying interest on the default, and the rate of interest is specified. Although excessive, although usurious, we have agreed to pay that. That is the sum and substance of the agreement. Now, so far as the question is concerned here, of course, your lordship will now find at clause page 170, there's a clause which provides for events of default, clause 16.
Yes.
Okay. Please see events of default. That's at page 170.
Yes.
16.1 says each of the events or circumstances set out in the following subclauses of this clause 16 is an event of default. It is hereby agreed to between the parties hereto that the lender shall have the sole discretion to determine whether an event constitutes an event of default. I don't have to read any further. Then, my lord, one of the events of default at 16.1 is non-payment. The borrower does not pay on the due date any amount payable pursuant to a finance document. That is one of the events of default. Then your lordship will kindly have a look at, now, clause 17, consequences of, an event of default. Page 174. Starts at 173.
Yes.
Consequences of an event of default. At 174, your lordship will find Well, 17.1.1 is cancel or terminate any available commitment. Well, here the money has been disbursed. 17.1.2 is declare that all or part of the loan, together with accrued interest and all other amounts accrued or outstanding under the finance documents, be immediately due and payable, whereupon they shall become immediately due and payable. Now, let kindly mark the words all or part of the loan. Now, my lord, here, if your lordship reads, my lord, the whole agreement, my lord, in a harmonious manner, then, my lord, what it means is, my lord, if there's a default in payment of the principal, in that case, my lord, that can be cured, or, my lord, that can be ultimately compensated by, my lord, the interest provision. So, my lord, here it is only in the event of default in payment of the interest that, my lord, this really can be, my lord, called into effect. My lord, that is, my lord, how we read it. Consequence of default, and, my lord, will kindly see. My lord, ultimately, it is a matter of election, of course. But, my lord, next, your lordship will kindly have a look at, my lord, what happened in this matter. Well, your lordship will, my lord, have a look at. My lord, so far as loan is concerned, well, the entire amount of loan, well, I should need to show you lordship one more thing. Well, please see, well, paragraph 22 of the petition once, 23 of the petition, at page 17.
Yes.
My lord, paragraph 23, my lord, shows as to when, my lord, and what installments were to be paid.
Yes.
Now, my lord, so far as serial number 1 is concerned, 5th October 2022, 7 crores paid. Serial number 2, 5th January 2025, 7 crores paid. Then, my lord, serial number 3, my lord, 5th April 2025, 12.75 crores was to be paid. My lord, this was not paid on, my lord, the date. Now, my lord, so far as this is concerned, my lord, this is, my lord, the event of default that my learned friends say. Now, my lord, very important. I have already, my lord, stated on record that, my lord, in respect of the previous installments also, my lord, there were certain delays in payment for which, my lord, they ultimately recovered the payment with interest.
So
Now, my lord, here also, my lord.
What is the date of the default?
Yes, my lord. Your lordship will kindly have a look at the notice of default. That is, my lord, that is page 587, volume 4.
Yes.
Well, at paragraph 3, paragraph 4. What was the loan agreement to put that? You can schedule it.
Failure to pay outstanding constitute new.
Well, this is the notice that they, my lord, ultimately issue, serve on us. Well, on the 28th May 2023.
As on 28th May 2020, 15 crore 40 lakhs 90
Now,
lakhs outstanding.
Now, my lord, very interestingly, my lord, this is very important. My lord, your lordship has seen, my lord, this clause. It says, as on 28th May 2025, amount of 15 crores 40 lakhs 96,746 is outstanding.
Correct.
My lord, the total amount of my lord installment is 12.75 crores. How does it become 15 crores 40 lakhs? With interest.
Including interest.
Yes. Now, my lord, they are asking me to pay this interest. They are charging interest. But, my lord, they're saying that the entire money will now become due. My lord, it says, paragraph 4, we are constrained and hereby recall the entire loan. My lord, lordship has seen, my lord, page 588.
Yes.
Kindly see the contradiction here. In the circumstances, we state that the failure to pay the outstanding amount constitutes an event of default as contemplated under clause 16 of the loan agreement. In view thereof, we are constrained and hereby recall the entire loan. And then say, further, the lender shall further exercise all available rights to us under the finance documents and or under law and under equity. As on 28th May 2025, an amount of rupees 15 crores 40 lakhs is due. Well, which is the amount due with interest. Page 190. Well, please see, my lord, the schedule, my lord, of payments from the agreement itself. My lord, that is at volume 2, page 194.
184.
194, my lord. আমি দেখাচ্ছি সব দেখাচ্ছি। My lord, this is the schedule. And my lord, please see page 195. My lord, clause 10 is very important. My lord,
94.
interest is, my lord, 13.25% per annum.
194 is schedule.
Yes, my lord. My lord, clause 10, your lordship will find at page 195,
Yes.
provides for payment of interest at the rate of 13.25% per annum linked to PPR currently, etc. That's clause 10.
Yes.
Then clause 11, default interest. My lord, this is what we were talking about.
24%.
24% per annum.
So this 15 crore they have
Is
asked for.
with 24%.
That
my
is
lord.
with regard to 24% or 13%.
No, my lord, 13%, my lord, was the original, my lord,
Original.
rate of interest.
Correct.
Well, this is, my lord, the default, my lord, interest that is being charged.
They have charged the default also.
Yes. Now, my lord, also kindly see, my lord, clause 15, my lord, which is the security cover. My lord, although, my lord, kindly see, it says post creation of security, borrower shall maintain minimum cash cover of 1.48 into security cover of 2.04 after interest during the entire tenure of the facility, and same shall be monitored. Any shortfall in security should be made good. Now, my lord, security is to be proportionately reduced with the repayment. The entire security is still intact, no reduction. Now, my lord, here may I show your lordship, so far as this is concerned. Now, your lordship will see, my lord, so far as the loan is concerned, we have repaid the loan. My lord, please have a look at, my lord, now paragraph 60 of the petition. My lord, this is the quarter, my lord, that fell due in April.
Yes.
My lord, paragraph 60, my lord, this is how we have paid.
Yes.
My lord, this is, my lord, the amount which had fallen due in April 5, 2025.
Yes.
Now, my lord, this amount, entire amount has been paid,
So
my lord, in three tranches.
up till 18 June 2025.
Yes, 18 June 2025, entire amount paid. And my lord, kindly see, what is the amount paid? 16 crores 62 lakhs 37,403.
That includes that 15 crore.
Yes, yes. So, my lord, we have in fact made an excess payment. My lord, kindly see, my lord, the next page, excess payment is 7,28,223. And my lord, here, please see, excess paid after taking into account further penal interest until 18 June 2025. So, my lord, the entire money has been paid. Now, my lord, notwithstanding payment of this entire money, my lord, your lordship will now see, my lord, what is happening.
Yes.
My lord, please come back to the notices once. My lord, first notice was, my lord, 28th May. Your lordship has seen that notice already.
Yes. 587.
Now, my lord, so far as this is concerned, my lord, please have a look at it once again. My lord, please see page 589, how they are calculating this sum. That was your lordship's query.
Yes.
Principal, 12 crores 75 lakhs. Interest on principal, 199,22,699. Additional default interest charges, 663,959. My lord, total works out to 15 crores 40 lakhs 96,746. And my lord, this is the amount. My lord, kindly see the next paragraph. We hereby call upon you to repay the total outstanding amount of 15 crores 40 lakhs 96,746 within a period of 15 days. And my lord, here the contradiction is at the same time they say in paragraph 4 that we are constrained to recall the entire loan. So, my lord, they admit that 15 crores 40 lakhs is due with penal interest.
So this was on 28th May. As on 28th May, this was the amount.
Yes, that's right.
When you have paid that.
My lord, we have paid it on 16th of June, my lord,
16th of
and my lord, we have calculated interest up to that date. Penal interest up to that date. That I have showed your lordship.
Yes.
Now, my lord, please see thereafter, my lord, the further notices that follow. My lord, your lordship has seen here Well, the representation is that this is without prejudice to all our rights, including my rights to enforce all the security interests. Well, that is the matter. Then kindly see the next page at page 591. This is the next notice. After 28th May, we have a notice dated 8th June.
Yes.
Now, kindly see 8th June. Well, it is addressed to Money Reality, that is the borrower. Well, please see the chart. Well, here they claim that the entire amount has fallen due. But before that, kindly see subject is very important. Payment of due intimation notice. Below is the facility with due for the month of June 2025. So, they identify this is what is due on the month of June 2025. But what they recall is the entire amount in two notices. One is the notice at page 591 and the second notice is at page 593. Well, one very interesting piece of information is, initially, the loan had been given to plaintiff number one. Plaintiff number one could not pay the entire loan amount because of two things. One is COVID, and second is because they started charging interest at excessive rates beyond the terms of the agreement. Ultimately, they said, very well, we'll restructure that loan. We'll decide on the matter of excess interest later. Now, so far as the loan is concerned, the loan was restructured by giving an amount of 106 crores to the plaintiff number two, which loan was used entirely to square off the loan given to plaintiff number one. That is how it was restructured. So, we have one of the claims in the suit is for the excessive interest that you've realized under loan one agreement, which was the loan given to the plaintiff number one.
How you can say the excessive interest?
I'm sorry, Malib.
Excessive interest, how you can say that the
Malib,
excessive interest? What is the principle? Main interest? 15%?
The principle is there was an agreement for charge of interest.
Correct.
They said that we will revise the rates of interest according to our own PPLR rates. And they also said there's a Reserve Bank norm which also ultimately says you have to be transparent and show as to how you are arriving at these rates. There is absolutely no discussion about how this increase was affected. We repeatedly made complaints. They said we'll look into it later. But I'm not agitating that issue before your lordship now. I am presently concerned with the second loan agreement.
Okay.
Admittedly, second loan agreement was given to square off the first loan agreement. The entire money that they paid us, we paid it back to them because the first loan agreement was squared. Second loan agreement provided for repayment in installments. I've shown you, lordship, what the installments are. We have paid the installments with interest. They have realized the rate, the tranches with interest on every time. And now they say that we are present due is 15.40 crores, but they ask for the entire loan to be recalled. There's a reason behind this. I'll tell you, lordship, why later. Then, please see the next notice at page 595. This is on 13th June. By which time I have paid almost the entirety of the outstanding installment.
Yes.
Your lordship seen by 18th June, the entire money was paid.
Correct.
13th June is the notice.
Yes.
Please see. At page 595, they gave a notice. Paragraph 2 at page 596. In view of recall of loan, the total amount of 92 crores 83 lakhs 54,040 became due and payable by you as of 11 June 2025. Now, my lord, very important. My lord, by the notice of 28th May, they had given us 15 days time to make this payment.
Yes.
Now, my lord, 15 days is not, my lord, has not yet expired. My lord, the entire loan is, my lord, sought to be recalled on 8th June and now, my lord, 13th June.
Yes.
Now, my lord, thereafter, my lord, your lordship has seen the entire amount is paid by 16th June. But, my lord, please see, my lord, now, my lord, the notice at page 597, 16th June, when they have received the entire money. My lord, this is notice issued to, my lord, the guarantor, pledgor, and mortgagor. Well, please see, Well, at 597, we refer to the guarantee executed by the guarantor in favor of our security trustee for the benefit of the lender to secure loan of 106 crores, availed by the borrower. Borrower has not fulfilled its obligations under the finance documents and other ancillary documents, and an amount of 92 crores 83 lakhs 54,040 as on 11 June 2025 is due and payable by the borrower. We hereby invoke the guarantee provided by you. Accordingly, we give you notice pursuant to clause 2.1.2 of the guarantee that we require you to pay such an amount within 7 working days from the date of issuance of this notice. Now, my lord, what is the amount that they call upon us to pay? 92 crores.
Correct.
Now, my lord, this notwithstanding the fact that we have paid the first installment that has fallen due with all, my lord, interest and penal interest.
Yes.
Now, my lord, please see, my lord, in this context, the next volume also, this is the statement of account. Volume 5. Well, this is the statement of account that they annex. First. Now, well, please see, well, this statement of account. This is on 30th June 2022.
Yes.
30th June 2022, 31st May
Yeah,
2025.
31st May.
I'm sorry, 31st May
30th September 2022 to 31st.
Yes,
May.
my lord. Now, my lord, kindly see, well, the second, my lord, principal amount overdue, position as on 31st May 2025.
Yes.
Well, at principal amount overdue is got to 7 crores. Yes. Well, at 5 crores, 75 lakhs, and my lord, 7 crores. My lord, that your lordship will find at my lord, first, my lord, 599, 5 crores, 75 lakhs, principal overdue.
Yes.
And then if your lordship, my lord, kindly comes to the next statement of accounts, 602. Principal overdue is 7 crores.
602.
Well, 602, my lord, is 7 crores. So, my lord, 7 and 575 is 1275.
Yes.
My lord, now this is, my lord, the position as on 31st May 2025. The loan recall notice was 28th May 2025.
Yes.
My lord, they accept that, my lord, the amount outstanding is, my lord, 12.75 crores. And they call upon us on 28th May to pay 15.40 crores, and we've paid the entire thing. Now, my lord, thereafter, your lordship will kindly have a look at.
So, but here is the overdue as on May 2025.
Yes. Well, May 2025, my lord, the agreement says if you do not pay within time, you'll pay interest. My lord, interest at penal rates. And my lord, we have paid that. My lord, that is, my lord, the long and short of the whole story.
Yes.
My lord, then, my lord, kindly see, my lord, we have been, my lord, communicating with them in this regard. My lord, please have a look at page 578 now. My lord, this is after, my lord, the entire payment has been made.
Yes.
578, my lord, email. So your lordship will see from the bottom, my lord, June 25, 2025. This is after the payment has been made. My lord, here, my lord, it is written from us. My lord, the mail goes from us, my lord, to the defendant number 1. Dear team, PFA statement of escrow account, we have received a sum of rupees 2.90 crores in the master collection account against unit number such and such of Rajesh Kabra. And then, my lord, next page you'll see, thus you are requested to recover amount of 2.76 crores as per attached statement. My lord, there's an escrow account maintained by the parties where all sale proceeds are to be, my lord, deposited. Now, my lord, we receive some money. We call upon them to receive this money.
Who has sent this
My
email?
lord, this is our sign. My lord, Mr. Pratik Khanna is our representative.
Okay.
Now, my lord, the reply to this is at page 578 at the top. Now, my lord, please see, this is also on 25th June 2025. My lord, here, my lord, the dear Tanvi, my lord, this is, my lord, from the defendant to its, my lord, own officers. Dear Tanvi, please recover. So, my lord, today again, my lord, the old system is, my lord, put back in place. Whatever payment I'm making, my lord, now they're appropriating towards recovery.
Yes.
My lord, in terms of the agreement. Then your lordship will kindly see 577. My lord, again, the instruction is given, my lord, with regard to this tranche of payment. My lord, it says, dear Tanvi, please recover. Now Tanvi is writing, dear team, please issue FT instruction, that is fund transfer instruction.
Where from you're reading? Page
My lord, page, my lord, 577.
577.
Your lordship saw that, my lord, we were writing the, my lord.
Please issue FT.
Yes. Now, my lord, dear Tanvi, please recover. And Tanvi then says to the team, please issue fund transfer instruction, FT instruction.
Yes.
Then your lordship will please see 576. My lord, now, my lord, the team is saying fund has been transferred. Now, my lord, all this happens on 25th June after the entire, my lord, outstanding tranche of the payment that had fallen due in April has been paid. My lord, this is, my lord, in respect of one set of payments. Then your lordship will kindly have a look at, my lord, then page 582. My lord, similarly, my lord, again, my lord, we say that we have received some money in the escrow account. My lord, please see from Pratik Khanna, 27th June, 582. My lord, from Pratik Khanna, it says 27th June, dear Piramal team.
582.
Yes, my lord, 582.
Yes.
My lord, your lordship will see the middle, my lord, email from Pratik Khanna, 27th June,
Yes.
at 10:45. Now, my lord, here it says, well, dear Piramal team, PFA statement of escrow account, we have received a sum of 2.36 crores.
Email time is?
Well, at 10:45. Well, this is the email at the middle of the page.
Oh, yes.
Well, again, well, this is regarding another payment. That was, earlier one was 25th June. This is 27th June. And well, again, Pratik Khanna is writing, Pratik Khanna is our representative. Dear Piramal team, PFS statement to escrow account, we have received a sum of 2.36 crores in the master collection account against collection of the project, the 42 at Middleton Street. You are thus requested to recover the amount of 2.26 crores as per attached statement from escrow account. And then, my lord, kindly see at the top of the same page, my lord, Sabera Agarwal of my lord Piramal, Sabera Agarwal at piramal.com is writing at 11:15 AM. Dear team, please recover.
Yes.
And my lord, similarly, if your lordship now sees at page 84, 27th June at 5:18. Well, I'm sorry, my lord, I need to show you, lordship, my lord, page 582 once more. I've just shown it, my lord, it is very important. My lord, 582, please have a look at, my lord, the my lord, bottom portion. My lord, this payment is, my lord, being offered. Kindly see the last line. Thus, you are requested to recover the amount of 2.26 crores as per attached statement from the retention escrow account towards the installment payment due on 5th July 2025. So, my lord, we are offering against the next installment.
Yes.
And my lord, similarly in 579 also, my lord, this payment was offered towards the next installment of July.
Yes.
And my lord, your lordship will see, my lord, page 584, my lord, this amount is funds have been transferred. 27th June at 5:18 PM. So, my lord, they agree to, my lord, again, my lord, receive payments towards, my lord, the future installments, my lord, that fall due.
Yes.
Now, my lord, the dispute, my lord, that arose, my lord, in these circumstances, because they insisted that, my lord, the entire loan is now recalled, and, my lord, they will proceed to exercise all their rights, including rights of, my lord, enforcing mortgage, including of right of, my lord, exercising pledge over the shares, My lord, that is why, my lord, today the entire matter has now come to a stalemate. Although, my lord, we are ready with the payment for the next installment. And, my lord, the agreement is you pay it with interest. Now, my lord, so far as this is concerned, please now, my lord, have a look at, my lord, why this has happened. My lord, it is unbelievable that, my lord, our lender, my lord, who is paid, my lord, the outstanding interest with penal charges, with penal interest, will, my lord, now, my lord, say, even after recovering, my lord, part payment against, my lord, a future installment, will now say that, no, I recall the entire loan. My lord, there's a purpose behind it. My lord, that purpose, your lordship, we have stated, my lord, at, my lord, paragraph 76 of our petition. But, my lord, before, my lord, I take your lordship the paragraph, my lord, the main purpose is, my lord, one of the securities offered by, my lord, the money group, my lord, which is, my lord, really the plaintiff group, my lord, is, my lord, the, my lord, majority shareholding in, my lord, a company called Mainam Properties, which owns, my lord, the Pink Mall at Jaipur. It's a very valuable property. My lord, the balance 33% shareholder of, my lord, that, my lord, company is the Satwa Group. The Satwa Group had, my lord, ultimately negotiated this, my lord, lending from, my lord, Piramal to, my lord, the plaintiff number 2. Now, my lord, Satwa Group and, my lord, the money group are in dispute in respect of other projects and properties. Matters, my lord, very highly contested before this court. Now, my lord, they have not been able to make any headway in those disputes. So, my lord, now they, my lord, call upon Piramal that you please recall the entire loan. Please recall the entire loan, notwithstanding the fact that, my lord, today they have paid off the outstanding installment with the interest and also made part payment towards the next installment, which you are now not prepared to now accept after having accepted first 2 tranches, saying that so far as this is concerned, now you have to pay the entire loan amount. Now, my lord, what they want to do is essentially invoke the pledge and to buy us out, my lord, in the, my lord, Rajasthan, my lord, company. My lord, that's the Mainam Properties. But, my lord, that is an important aside. We have said that this is the entire thing is, my lord, the product of collusion and, my lord, fraud. But, my lord, we are not on that right now. The question is, my lord, what is, my lord, the term of the agreement? And, my lord, how has the agreement been approached by the parties? My lord, in this matter, my lord, your lordship might also recall that, my lord, it is now, my lord, quite standard practice and, my lord, settled position of law that an account becomes NPA only 90 days after it falls due. Now, my lord, 90 days is nowhere near in sight. Well, they said that 15 days.
It's not the case of NPA.
No, not the case of NPA. But, my lord, the question is, my lord, before your asset becomes stressed, even under the RPA, under the RBI norms, the question is, my lord, you're trying to recall the entire loan and put me under pressure. Now, my lord, we have also stated that we have paid, my lord, a substantial amount towards the installment of July at paragraph 67. My lord, these are the 2 payments which I have drawn your lordship's attention to in the emails. And, my lord, your lordship has seen that, my lord, in the communications that have been made, they say that you have to pay the entire money that is now due, and they say that we are, my lord, calling upon you to, and we reserve a right to proceed against you in respect of all events of default, which is invocation of pledge, invocation of mortgage or foreclosure of mortgage, and, my lord, all other steps that, my lord, they can proceed against the borrower. Now, my lord, so far as this is concerned, just a little bit of the law, but if your lordship will kindly take up, my lord, the Contract Act once.
Yes.
Well, let's kindly see section 55 once. The lordships have, my lord, delivered several judgments on this section. Well, lord, section 55 has 3 limbs.
Yes.
The first limb proceeds on the premise that time is of essence.
Yes.
But your lordships have held, my lord, times without number when, my lord, an agreement contains, my lord, provisions for payment of liquidated damages, interest in the event of default. Time is not of essence. Now, my lord, the first part is, my lord, when a party to a contract promises to do a certain thing at or before a specified time, or certain things at or before specified times, and fails to do any such thing at or before the specified time, the contract, or so much of it as has not been performed, becomes voidable at the option of the promisee, if the intention of the parties was that time, if the intention of the parties was that time should be the essence of the contract. Now, my lord, what happens if time is not of essence of the contract? Even if it says it is of essence. Here, of course, there is no such stipulation. It says, if it was not the intention of the parties that time should be of the essence of the contract does not become voidable by the failure to do such thing at or before the specified time. But the promisee is entitled to compensation from the promiser for any loss occasioned to him by such failure. Now, my lord, the contract has an inbuilt provision for such compensation. And my lord, therefore, my lord, one is very clear from the terms of the contract itself that time was not of essence. Because, my lord, the contract itself contemplated an event of, my lord, such default and provide for compensation for such default by providing for penal rates of interest.
Penal interest.
My lord, now the question is, my lord, if this is the position of law, and my lord, I'm carrying authorities, but I don't think, my lord, I'll really have to cite them because the authorities are numerous in number and they say all that, my lord, even if a contract says that time is of essence, but it says there shall be a liquidated damage if you don't perform, there shall be an interest clause, there shall be a penalty provision, then time does not become of essence. Well, I shall hand up the judgments to your lordship, but my lord, let me just, my lord, establish the proposition of law that I'm canvassing.
Yes.
Now, my lord, the law is extremely clear.
Yes.
If time is not of essence, then you cannot, my lord, terminate the contract. You cannot avoid the contract. Your only requisite, your only recourse is by claiming penalty or damages. And, my lord, penalty or damages is here quantified in terms of percentage rates of interest. Now, my lord, what my learned friends are now really, my lord, purporting to do is, notwithstanding the fact that, my lord, there was a default and, my lord, there's a provision for payment of, my lord, compensation for the default, and that is, my lord, cured. And, my lord, we have even offered, my lord, payments for, my lord, subsequent which they have elected to accept initially against the future interest. My lord, now, my lord, they are trying to, my lord, unnecessarily exert pressure. And, my lord, the repercussions will be extremely serious because, my lord, this is, my lord, one of the projects. The fund is, my lord, taken for one of the projects, which is, my lord, an iconic project in the city. That's 42. My lord, which has come up. Besides, my lord, there are various other projects. Now, my lord, we have also stated that we have also entered into, my lord, agreements with, my lord, various, my lord, space purchasers, home buyers, etc., which will entirely come under, my lord, the scrutiny. And, my lord, I have performed. Well, I'm instructed that, my lord, so far as this, my lord, lender is concerned, in view of its, my lord, attitude that it has demonstrated, and, my lord, the attempt to, my lord, really, my lord, proceed, my lord, extrajudicially in a manner against me. Well, I am, my lord, instructed that, my lord, we will attempt to repay the entire loan this year and, my lord, get out of their clutches. But, my lord, as of now, the position as it stands is we have, my lord, cured the default for which the notice was issued. And, my lord, we have also made part payment, my lord, towards the next installment, which fell due in July. But, my lord, they now say that we will not accept any part payment from you. You have to give us the entire 92 crores or not, which still, my lord, stands due. And, my lord, that is my cause of action. Now, my lord, here, your lordship will kindly have a look at, my lord, the other agreements. My lord, there are corporate guarantees. My lord, these are the security documents that were, my lord, executed. There are corporate guarantees. Your lordship will find that at page 230. My lord, there is a share pledge agreement, my lord, which is, my lord, a matter of grave concern to us now. That is at page 256. There are, my lord, 2 indentures of mortgage, my lord, which your lordship will find from page 323 onwards. And, my lord, there are, of course, my lord, personal guarantees also. My lord, the threat is now to, my lord, proceed to invoke all of them, although there is no default. And, my lord, the only cause is that you had failed to pay within the time stipulated, and although you have now paid with interest, we shall proceed against you to recall the entire amount. Now, my lord, it is for these reasons that, my lord, we have really come up with your lordship because, my lord, the threat is perceptible. They have already held out the threat. The notices says that we shall, my lord, be able to seek recourse to all.
So what is your prayer?
Now, my lord, please come to my prayers. My lord, at page, my lord, 66. My lord, they have, my lord, recently also invoked the guarantee. My lord, after the filing of the suit and the, my lord, petition, the guarantee has also been invoked. Now, my lord, naturally, my lord, they will try to take steps against us, my lord, before the NCLT, my lord, for personal guarantee, for corporate guarantee, and, my lord, for this debt, etc. But, my lord, here we are before your lordship because, my lord, today the mortgage subsists, and, my lord, the mortgage is under threat. The share pledge agreement is there. The shares are under threat. And, my lord, if the share goes, if the, my lord, pledge is exercised on these shares, then, my lord, I lose control of the entire company which owns this very valuable project. My lord, now, my lord, here, my lord, if your lordship sees, my lord, so far as the prayer is concerned, my lord, at page 66, I have sought an order of injunction restraining the respond numbers 1 and 2, my lord, from giving effect to these notices.
Yes.
Now, my lord, if your lordship sees prayer C, injunction, my lord, from invoking the pledge. My lord, it's a running mall, and my lord, one of the my lord, most prestigious malls in the my lord, state of Rajasthan, in the city of Jaipur. My lord, this is my lord, known as the Pink Mall. And my lord, so far as prayer is concerned, my lord, that's not important. I'm really, my lord, for the time being, my lord, requesting your lordship to pass order in terms of prayers A and C.
Notice and invoke, yes, pledge.
Yes, my lord.
Yes.
Now, my lord, here, so far as my lord, the agreements are concerned, one thing I must point out to your lordship, my lord, so far as the loan agreement is concerned, my lord, there's a jurisdiction clause at page 200.
Yes.
Well, it says non-exclusive jurisdiction of Kolkata and Mumbai. Your lordship has found the last clause 21. Now, well, it says both my lord Kolkata and Mumbai will have jurisdiction. The share pledge agreement and my lord the mortgage documents, my lord, which are my lord really coterminous or my lord codependent on my lord the main loan agreement, my lord, there appears to be a mistake in the my lord share pledge agreement. Your lordship will please see my lord page 278.
No, 200 says the jurisdiction, non-exclusive jurisdiction.
Yes,
Okay.
but my lord, there is my lord a clause, my lord, in the share pledge agreement, which your lordship will find at 278, clause 14.3.
Page 200.
278.
Yes.
My lord, this says that my lord, the courts in Delhi will have exclusive jurisdiction. Now, my lord, nothing has happened in Delhi.
Where?
My lord, clause 14.3. Now, my lord, nothing has happened in Delhi. My lord, and my lord, lordship knows that law is, my lord, very clear that my lord, parties cannot by my lord consent confer jurisdiction on court.
But you agreed upon.
My lord, even if the parties agree upon it, my lord, if the law is that parties cannot by consent confer jurisdiction and nothing has happened in my lord Delhi, my lord, then my lord, this clause will not my lord bind us or govern us.
Yes.
And my lord, so far as the mortgage documents are concerned, please have a look at the mortgage deeds. My lord, page 373, volume 3.
Yes.
Now, my lord, please see 27.10. Courts or tribunals of Kolkata shall have non-exclusive jurisdiction. So, my lord, it's obvious that, my lord, the share pledge agreement is, my lord, contains a mistaken clause because there are two mortgage deeds. Even the second deed at page 430 contains the same clause. My lord, courts in Kolkata will have non-exclusive jurisdiction.
Yes.
Now, my lord, both the mortgage properties are within the jurisdiction of this honorable court. My lord, we have accordingly, my lord, obtained clause 12 leave. And my lord, there is no application for revocation of such leave before your lordship. And my lord, the threat is, my lord, real because, my lord, your lordship has seen the letters. And my lord, the purpose of the threat is, my lord, very, my lord, evident. My lord, it is ultimately, my lord, at the instance of a third party to, my lord, put pressure on me because they have, my lord, when, my lord, a bank or, my lord, an NBFC or any other lender receives, my lord, interest on, my lord, the principal amount with, my lord, the default provisions, my lord, at the penal rate, well, then it is inconceivable that they will, my lord, try to recover the entire loan. Well, that is the reason why I am pressing for these release. My lord, here, my lord, just one more thing. If your lordship will kindly have a look at, my lord, the parties now, my lord, to the petition once.
Yes.
My lord, plaintiff number one is, my lord, the previous borrower under the 2018 loan, which has now been satisfied, but is now, my lord, the guarantor, mortgager, and pledger. Plaintiff number two is the present borrower. My lord, defendant number one is the NBFC, my lord, lender. Defendant number two is the, my lord, the trustee, my lord, security trustee of the lender. Number lord, 3, 4, and 5 are members of, my lord, the, my lord, Jhunjhunwala family, which controls the money group. And they have each given, my lord, personal guarantees and also pledged their, my lord, securities. So, my lord, here, my lord, your lordship will find that, my lord, each of their interests, my lord, is ultimately entangled in this litigation. And, my lord, kindly see, my learned friends are now, my lord, seeking to do what? They are seeking to, my lord, appear to defend this, my lord, action or to oppose, my lord, my prayers, because they say that no, we should now be given the liberty to, my lord, recall the entire amount that is due and to take whatever steps we need to do for that purpose. Well, this in itself, well, shows purpose and intent, and the intent is clearly malafide. Well, these are the reasons why I prayed, my lord, before your lordship for necessary injunctive reliefs.
Thank you.
Got a question that fell from my lord with regard to one of the previous loan. And I just wanted to show my lord one paragraph. We have also asked for a decree. Though, my lord, it's not relevant so far as that is concerned, my lord, for the interim order. But just kindly come to, my lord, paragraph paragraph 24.
You are appearing for plaintiff number one.
One, my lord. No, no, no. We did on. Lord,
I'm sorry, my lord, I forgot,
Sorry.
my lord, I told you lordship about judgment. I shall, my lord, just, my lord, refer to the 3 judgments and, my lord, hand up copies to your lordship. My lord, the first one, my lord, which says, my lord, when, my lord, provisions like, my lord, liquidated damage clause, etc., my lord, are there in the agreement, the time cannot be said to be of essence. This is All India Reporter, 1979, Supreme Court, page 720. My lord, the relevant paragraph are 7 to 10. My lord, may I just hand it up to your lordship? Well, this is the SCC, my lord, citation is 1979, volume 2, Supreme Court cases, page 70. Paragraph 7 to 10. Then, my lord, the next judgment is 2006, volume 11, Supreme Court cases, page 181. My lord, paragraph 83 onwards. And that, my lord, even when time is of essence, my lord, by contact, the parties can waive it. My lord, for that, 2002, volume 4, Supreme Court cases, page 45, paragraph 15. It is okay. My lord, these are the 3, my lord, cases that I wanted to rely on section 55.
Yes. Yes.
Yes, my lord, kindly. My lord, my lord, what fell from my lord? Page 24, my lord, I'll just show my lord what is though, my lord. Again, my lord, I'm saying this is not relevant so far as the interim order concerned. Page 24, my lord, of the petition.
Yes.
So far as, my lord, the previous loan is concerned.
Yes.
My lord will find, my lord, because this entire, my lord, for the new loan, my lord, it's already been told, my lord, that the money had to, my lord, go and, my lord, pay off, my lord, the previous loan. Kindly, my lord, look at, my lord, the report date. This is, my lord, the RBI report date. Fourth column, my lord. While, my lord, it is going down 6.5, 6.5, my lord, 6.25. The Piramal prime lending rate is going up. And, my lord, this is what has been recovered, my lord. That's the third column.
So repo rate 6.5, Piramal prime 16.35.
And recovered from me, my lord, 15.0.
Recovered from Dixon 15.0.
I'm just showing an example, my lord. Then it's going down, my lord, which is 6.25. And, my lord, it's 16.50 what is recovered. Then, my lord, the last entry there, my lord, the last row, my lord, will find 5.40, recovered 16.50. for this, my lord. So I'm just showing, my lord, this is how, my lord, quite naturally, my lord, financial institutions sometimes. And here, my lord, in the next page, my lord, we'll find page 25. My lord, item number 15, 14, my lord. Yes, kindly look at 13.
18.65.
Yes. 4 is RBI rate, my lord. Their rate, my lord, becomes 20, and then, my lord, recovery is 18.65. Now, my lord, for that, my lord, we have made a claim, my lord, that will come, my lord, when. Now, my lord, next, my lord, very important, in the pledge agreement, my lord, will kindly come to, my lord, page 273, because that's, my lord, our case. Kindly see, my lord, page 273, clause 9, volume 2, my lord. I'm so sorry, my lord.
Yes.
Volume 2. Paragraph 9, my lord, will find invocation of the pledge upon the occurrence and during the continuance of any of the following events. Because our cases, my lord, will recall, my lord, all this has been shown. My lord, the dates are, my lord, 4th April, then 4th July. April, my lord, they up to, my lord, I think the last one of the letters, my lord, 16th April or 23rd April, when they say you pay 15 with penalty, 15 crore. Then, my lord, though the letter of 28th May, they say we are calling the entire loan is being recalled, but they ask for 15 crore.
Correct. As on
That's
28th May.
Correct. With, my lord, interest and penalty, which is, my lord, paid in June. Now, my lord, if they have accepted it, then, my lord, no question of then, my lord, going back and saying in June itself that we want to recall them.
So that's the Mr. Shah's argument.
That's right. That's right.
Once they have accepted the amount along
Correct.
with the interest, in terms of the agreement, so how they can recall this?
That's the main.
If it is a penalties prescribed in the agreement, the penalty is doing the agreement can continue.
Absolutely.
That is the
My lord, yes, well, absolutely, my lord. That's, my lord. And just 2 more points, my lord. First and second, my lord, is on the question that, my lord, the pledge which is there, my lord, this was, my lord, 2x at that time. So, my lord, the principal, my lord, I find, my lord, 70 crore. It's not that, my lord, they are not secure. They're completely secured so far as the loan is concerned. Now, my lord, one last thing, my lord, at page, my lord, volume 5, my lord, will find, my lord, our email of July 4th, which is page 680. This is, my lord, the last one.
yes.
My lord, will recall, my lord, by this time, for the July installment, we say this is part payment for July installment. Please accept it. They have accepted it. So, my lord, that is also, my lord, another, my lord, contrary, my lord, thing to, my lord, saying that the whole loan is recalled. Then page 680, my lord, sees this has reference to the principal and interest installment falling due on 5th July against a loan of 106 crores available by Money Realty. In this regard, please note that we had paid an aggregate sum of 5.02 crore, 2 installments in 2 tranches. The first being of 2.76 crore on 25th, and the second being of rupees 2.26 on 27 June. Well, this has been shown by Mr. Shah. Thus, you are requested to provide the details of the balance principal and interest installment falling due on 5th July after deduction of the aforesaid amounts. Now, they write back saying, page 679.
Yes.
Well, the total amount, is 74 crores. 74 crores. Now, my lord,
discuss with you, please.
the installment amount, my lord, is 12 crore and odd. I paid already 5. I'm asking for what is the balance due for July. So, my lord, this malafide of theirs, my lord, is also, my lord, now evident that, my lord, they say the entire amount is outstanding.
So 106, you have paid the 5.02 crore in 2 installment, and you ask for the details.
Yes.
They have given the total amount. They have what the 679?
Yes, 679, my lord, in 10 4, my lord, we have paid already, my lord, this
Correct. The 680.
71 crores principal is outstanding. That is, my lord, what?
Correct. The
Yes.
principal outstanding.
Yes. So, what I'm on, my lord, is when I ask them that what is the outstanding amount as on 5th July, because, my lord, that's when the installment has to be paid. They, my lord, malafide, my lord, they say no, you pay the entire amount. Which is, my lord, what is, my lord, the objection against?
Yes.
My lord, and the cases have been shown, my lord, those are my. Sir, my lord, and one, my lord, I'm so sorry, my lord, in the prayer, my lord, I'm also subject to what, my lord, ENF. My lord, particular photo. my lord, prayers, kindly, my lord, page 68. I have also, my lord, made this prayer telling me, my lord, for them to, my lord, tell me what is the amount due, my lord, not, my lord, the installment amount and not, my lord, the entire. E and F also, my lord, will kindly consider, my lord, that.
E with regard to the correct particulars.
Correct. July installment.
And restoring the refund to agents assigning a party.
And, my lord, F is, my lord, that not to, my lord, hand over, my lord, any of the documents, my lord, relating, my lord, to the pledge. Because that will, my lord, contrary to, my lord, their stand, my lord, in breach of, my lord, the agreement, my lord, which is now subsisting, my lord, between the parties. And, my lord, shares, my lord, are in physical form, my lord, lying, my lord, with the different number 2.
Security.
Yes.
Yes.
Those are.
Lord, I'll take 1 minute. My lord, I am Millard for a supporting respondent. That's respondent number 3. My lord, I've been told by Mr. Sarkar, my lord, I cannot exceed 1 minute. My lord. So, my lord, I'll my lord, honor that request.
But purpose is present is recorded. Why do you have to report?
Now, my lord, kindly take, my lord, annexure P, my lord, which is at volume 4, page 462. Lord, the respondent number 1.
462.
Yes, my lord. Being, my lord, an NBFC is required to have a fair practice code. And, my lord, being, my lord, a housing finance company. Now, kindly have a look at, my lord, 462. My lord, just, my lord, 1 page, my lord. Kindly come to, my lord, 460, my lord. My lord, kindly see, my lord. 4, my lord, 72.
Yes.
My lord, kindly see recovery of loans.
Yes. Yes.
My lord, the company, that's, my lord, the, my lord, respond number 1 shall put in place a mechanism for identification of the borrowers facing repayment related difficulties, engagement with such borrowers, and providing them necessary guidance about recourse. Now, my lord, I just pause here. My lord, your lordship's being shown, my lord, the letters. The outstanding amount, my lord, has been paid. It was, my lord, 1 default. That's what they asked for. My lord, they got it. Then, my lord, no sitting, my lord, with, my lord, the borrowers, and, my lord, the entire amount, my lord, is being demanded after an election, my lord, has been made as to how much they wish to recover. And, my lord, your lordship may kindly note this. My lord, the, my lord, plaintiffs, my lord, I'm not saying, my lord, that kindly note, they have been defaulters, my lord, in the past by, let's say, 10 days, 5 days, 20 days. My lord, never have they taken, my lord, this step. So, my lord, if, my lord, they are, my lord, the one with the money, my lord, who, my lord, provided also for, my lord, large projects. My lord, all of a sudden, my lord, to do this, my lord, all that I'm saying is, my lord, where, my lord, they have to maintain transparency, fairness, my lord, also, my lord, the concerns of the borrowers, my lord, have not attempted it at all, and, my lord, contrary, my lord, to past, my lord, conduct, where, my lord, there was, my lord, complete transparency, discussion, acceptance, my lord, of, my lord, delayed payment, my lord, and it's never been an NPA. Never been an MBA. It's, my lord, always paid, my lord, before that. My lord, your lordship will also find this, my lord, in the petition, my lord, paragraph, my lord, 50, my lord.
It's 34. It's 34.
Page 34, my lord. Kindly have a look.
Yes.
My lord, paragraph 50. My lord, this fact is, my lord, stated. My lord, page 34.
Yes.
75 to the
And my lord, paragraph 75 also
page 46.
at page 46, my lord, your lordship kindly sees.
Right away. Watchman not treated even fundamental.
My lord, kindly see, petitioner submit that in case of delay in repayment on the respondent entitled to levy penal interest, furthermore, such is a curable default. Now, my lord, the fact. Petitioner submits that in the past, petitioner number 2 has been servicing pyramidal loan with a marginal delay of 10 to 70 days, and respondent number 1 has not raised any objection since petitioner number 2 has also paid penal interest on such amount. This further evinces that respondent number 1 has not treated repayment of monthly installment within stipulated date as a fundamental condition to the loan agreement, breach whereof would entitle the respondent number 1 to recall the loan. Most importantly, the outstanding amount coupled with penal interest, although illegally computed and levied, thereto has been duly paid by petitioner number 2, respondent number 1, and as on date, no amount is due and payable in such circumstances. This is a fact, my lord, which has happened.
Statement to support it.
And my lord, the bank statements which are on record, my lord, also my lord support this. My lord, all of a sudden this is happening, my lord. Is my lord what my lord raises, my lord?
Yes.
My lord issue, my lord, about my lord transparency. My lord, those are.
আপনি যদি support না না আমি তো ছোট point.
Yes.
আমাকে বলো না এটা কলকাতার একটা ভালো প্রজেক্ট নষ্ট করে দিল।
Well, there's a fundamental fact, my lord, which is my learned friends have not mentioned. Well, on 14th of June, my lord, we served a copy of a proposed application, my lord, under the Insolvency Code as a financial creditor to be filed before NCLT, my lord, Additional Authority, my lord, Kolkata. And then we filed it. And my lord, we also gave them notice, my lord, after that for filing, but it's not mentioned in the petition. My learned friends we not know about it. All service by email. Well, I can, my lord, give them the copy and give a copy to your lordship, my lord, 1426. Oh, the copy though. My learned friends may not know about it, my lord. I'm not surprised. It's a counter. 14 or 22 to 26. And my lord, these are notices given, my lord, really, my lord, by the legal firm. Can you see 14 June, my lord, from August Partners? appear for so-and-so, service, my lord, pyramidal, final section 7 application in 4 volumes, volume attached, my lord, so-and-so, my lord, we have given notice. And then, my lord, we filed it. Well, we have to, my lord, give notice and file.
You got a number?
My lord, he mentioned that, my lord, in paragraph 87.
Yes, we mentioned.
We mentioned it.
Yes, my lord, no, but
It's not numbered as.
no, should have pointed out to your lordship, it has a, my lord, fundamental jurisdiction question involved. And my lord, we have served, my lord, after filing, my lord, 26th of June, DHO copy. That, my lord, on the same, my lord, from lawyers, my lord, has been served. Now, my lord, 2 points arise here. A fundamental question. Now, my lord, the Insolvency Code, my lord, is exhaustive. My lord, is a complete code in itself. I've already filed, my lord, an application where, my lord,
You are appearing for all.
on 1 and 2, my lord,
One and
1 and 2. Filed, my lord, application as my lord, a financial creditor. On the basis of, my lord, let's say, my lord, my learned friends, my lord, contentions are sound. The forum where they can raise this point, my lord, is not before a lordship, my lord, but before the adjudicating authority, my lord, hearing the event of default. If there's no default, my lord, the application will be dismissed. If there's event of default, my lord, law will take its own course. Now, my lord, lordship, my lord, with respect, does not have jurisdiction to go into the matter. Kindly take the Insolvency Code. My lord. It's very clear. I'll give you, lordship, a copy, my lord, if it's not there.
Yes.
Take, my lord, first section 63.
Yeah, अच्छा এখানে আছে।
Lordship got, my lord, section 63.
Yes.
Civil court not to have jurisdiction. No civil court authority shall have jurisdiction to entertain any suit or proceedings in respect to any matter on which the National Company Law Tribunal or National Company Appellate Tribunal has jurisdiction under court, this court, civil court not to have jurisdiction. But I've already filed.
Yes.
So, my lord, civil court has no jurisdiction, my lord,
to go into the matter, my lord, relating to my lord, default, which is my lord, the subject matter of the application, my lord, that we have filed.
Yes.
And my lord, lordship will find also, my lord, section 60, subsection 5A. That is, my lord, exclusive jurisdiction, my lord, to the National Company Law Tribunal. 5A. Anything to contrary any other law for the time being in force, National Company Law Tribunal shall have jurisdiction entertain this for any proceeding by or against the corporate or corporate person. So now, my lord, kindly, my lord, come to section, my lord, 231. That, my lord, clause section is repeated. Bar of jurisdiction. (231).
Yes. Yes.
No civil court shall have jurisdiction in respect of any matter in which the adjudicating authority on the board is empowered by or under this code to pass any order.
Yes.
And no injunction shall be granted by any court or other authority despite any action taken or to be taken on this person so and so by. It's very clear. Now, 238 now, lordship will consider provision of this code override all other laws. Provisions of this code shall have effect notwithstanding anything inconsistent therewith contain any other law of time being in force in so and so. So, my lord, with respect, I submit, my lord, this court has no jurisdiction to entertain this matter at all. Let alone, my lord, going any further. If lordship wants, I can cite, my lord, to authorities for this purpose. First, my lord, Supreme Court. That, my lord, this is a complete code. IBC Supreme Court.
Why you have not raised this up before the
sorry?
submission of Mr. Shah? Why you have not raised this question before Mr. Shah has argued the matter?
Why I didn't raise? Well, my learned friend had, my lord, they had prepared themselves, my lord, so exhaustively. Now, my lord, it's a triple barrel gun, my lord, not even double barrel. So I thought, my lord, learned friend, my lord, should at least the work, my lord, should have the advantage of the research that they have carried out. My lord, I thought it will not be proper. My lord, otherwise, he's interrupting. So, now, my lord, this Supreme Court recent judgment, my lord, deals with, there are many judgments. I'll give you a recent one, my lord. Here, paragraph 15. Oh.
For the enterprise.
Tanzania limit.
Apart from delay and leach, paragraph 15, minute.
Yes.
Delay and leaches, High Court should have noted the Insolvency and Bankruptcy Code, the complete code in itself, having sufficient checks and balances, remedial avenues, and appeals. Adherence of protocols and procedures maintains legal discipline and preserves balance between the need for order and the quest for justice. The supervisory and judicial review powers within the High Court represent critical constitutional safeguards. Yet, the exercise demands rigorous scrutiny and judicial application. Such not a case for the High Court interdict CRP proceeding under Insolvency Code is above allow the appeal. So they have wanted High Court Mullah restrain proceeding going. Now, Mullah, the other point, Mullah, which lordship wants, there is Delhi High Court judgment, Mullah, dealing with Mullah section 63 and 231. Lordship, Mullah, kindly takes, Mullah. Paragraph 29.
Yes.
Also, crucially, particularly with respect to prayer C of the plaintiffs, in Chandigarh Overseas Private Limited is undergoing corporate insolvency resolution process. The present suit is precluded barred under section 231. Then, my lord, section, my lord, is quotation there, my lord, 31, and the lordship will see ultimately 31, my lord, is quoted. 63, 231 creates a bar on jurisdiction of civil court. And, my lord, paragraph 32, my lord, expressly controversy sought to be raised in the present suit subject matter proceeding so and so as such suit is not barred. And if you look at the prayers, kindly see prayers, my lord. Take a prayer, paragraph 2. all about my lord, assignment deed being valid and invalid. Then my lord, direct produced books of accounts to found out the amount due. And my lord, very similar, my lord, it's understandable. My lord, I'm not, my lord, answering on merits at all. I may be right, I may be wrong. Lordship does not have jurisdiction, my lord, to go into the matter. My lord, must be, my lord, sent back there. My lord, they can appear there as and when, my lord, the matter will appear, we can notify them. The other point, my lord, is also of some relevance. Now, my lord, what is the impact of the interim order they are now seeking to, my lord, ask for? People, my lord, if I, my lord, suppose, my lord, the respondents want to proceed, my lord, in a court or anywhere else, my lord, on the basis of the default notice. My lord, that with respect, my lord, cannot be restrained, my lord, by this court. My lord, before, my lord, at some stage, my lord, we had a practice, my lord, of filing suits to restrain, my lord, binding our proceedings. Very similar, my lord, to insolvency proceedings here. Alleging, my lord, that there is disputed debt. No, my lord, binding our proceeding can start. My lord, matter went to Supreme Court in 1983. Supreme Court said the court has the jurisdiction, my lord, to restrain any party, my lord, from initiating a legal proceeding. It's not permissible, my lord. The effect of the prayer which Narayan are now asking, my lord, is that, my lord, respondent number 1 and 2 cannot initiate any proceedings. That's the effect of, my lord. No effect, my lord, given default not involved. Default has taken place. I want to proceed in the matter. I've already proceeded. Can't, no, that I'll give one judgment, my lord. Lord, should we look at that? The
Yes.
Cotton Corporation case. I don't know about it. 1983, 4 Supreme Court cases, 625. That's it. No, paragraph 2. If you remember, this matter went from Calcutta High Court, in fact.
625.
And my lord, should we find, my lord, in head note itself, my lord, it is said, all the English cases were cited. Paragraph 40. Paragraph, my lord, 29. My lord. Kindly take paragraph 29. I'm sorry, 23. It's 22, my lord. I think Mr. Sen's argument, my lord, is quoted in paragraph 22.
Serious effects, that is what they are saying.
My lord, that, my lord, the argument they are making now, that will be serious consequences, my lord, of status and so on. Para 23, my lord. Turning to the facts of this case, let me recall the learned single judge had declined to grant a temporary injunction in the present appellant, the corporation, in our opinion, rightly. The appellate bench interfered with the order for the reasons which are far from convincing. It overlooked the provision contained section 41B and the effect thereof. The most favorable view of the appellate bench, assuming the bench had its mind inherent power of the court to grant injunction despite statutory inhibition, so and so, then to order to justice between courts for the affirmative finding that the binding petition as and when presented by the corporate creditor would be frivolous, would be considered and so on, so, my lord, and lordship, my lord, no injunction can be done. And it's been followed, my lord, repeatedly, my lord, and lastly, my lord, even in 2022, my lord, it's been followed.
Yes.
And, my lord, 41B of specific relief act, my lord, is quoted, I think, my lord. That, my lord, should we find the judgment, my lord? Paragraph 7 is quoted. Of Cotton Corporation judgment, take, my lord, paragraph 7, 41, oh, very well. Paragraph, my lord, 51 of the 2022 judgment. The section is quoted.
Yes.
My lord, it says, my lord, an injunction cannot be granted, then B, my lord, to restrain any person from instituting or prosecuting any proceeding in a court not subordinate to that from which injunction is sought. So, my lord, a restraint of a legal proceeding, my lord, except subordinate, my lord, courts, my lord, cannot be granted. And, my lord, that judgment is followed. Lordship will see that from Cotton Corporation. That your lordship will find, my lord, is mentioned there. And, my lord, finding is, my lord, injunction was refused. Cotton Corporation, lordship will find in paragraph 52.1. And then, my lord, 52.2, whether it's maintainable at all. Now, my lord. Now, if your lordship wants, I can show, my lord, the form number 1, my lord, which is for the insolvency code, my lord, form, which, my lord, deal with event of default, which, my lord, they have a right to answer, my lord, the event of default, my lord, as and when, my lord, the matter comes up. And, my lord, yes, and, my lord, we have said, my lord, we have mentioned the recall notices, my lord, which we have, my lord, in place. I am not troubling your lordship, my lord, with that. That is, my lord, what we have said, my lord. But as I say, my lord, I am not answering the merits. We will be right, we will be wrong.
Paragraph 9.
Paragraph 9, my lord, is
Top of page 15. In view of first default.
and then, my lord, we have mentioned about the June letters also. Then, my lord, 13 June, 9 and 11, all those, my lord,
Which
documents.
page, paragraph, page 15 of?
Paragraph 15, para 9.
Para 9. This is our application, my lord. These are the.
Achha,
No, no.
there.
Section 7.
Okay, okay.
Subject
It's not
matter of
required. It's not really required, my lord. It's those same documents my learned friends have mentioned, my lord. I'm only pointing out these are documents on
subject matter
from the subject matter of, my lord, the insolvency application. They have a copy, my lord. We served them with a copy. Depend করতে।
Yes.
Now, my lord, I can, my lord, answer on the merits also if your lordship wants, my lord.
Let me hear
My
you.
lord, if this point, my lord,
Let me hear regarding this.
yes, my lord, then, my lord, I don't need to. Well, if I required, my lord, I'll come back,
Yes.
my lord, on the merits.
My lord, may I, my lord,
Yes.
trouble your lordship again, my lord, but this time 5 minutes. My lord, on this, my lord, they are the ones who have to do it first. But my lord, my lord, want to, my lord, just indicate, my lord, one thing. My lord, if, my lord, there is no dispute that the grievance raised, my lord, by the plaintiffs, my lord, is, my lord, of a civil nature. Now, my lord, it has to, my lord, have, my lord, some form of, my lord, a forum from where, my lord, redress can be obtained. That's number 1. Now, my lord, section 9 of the Code of Civil Procedure, my lord, says, my lord, unless there is an express bar, my lord, or an implied bar, my lord, they can, my lord, approach,
Maintain
my
the
lord, the civil court. Now, my lord, the fact of the matter is, till such time, my lord, my lord, company petition, my lord, filed by my learned friends, clients, my lord, is admitted. My lord, there is no bar, my lord, to, my lord, proceeding, my lord, with these. Now, my lord, why do I say so? My lord, kindly take my copy, which was here. Just here. My lord, your lordship has an, yes, my lord, an IBC, my lord, if your lordship has an IBC. My lord, kindly take section 14.
Yes.
Now, the admitted position is, my lord, the petition which has been filed, even today doesn't have a number because it's under scrutiny. It has not yet been admitted because, my lord, before admission, a hearing is given. Now, my lord, kindly have a look at 14.
Yes.
Subject to the provisions of subsections 2 and 3 on the insolvency commencement date, which is, my lord, the order of admission, the adjudicating authority shall by order declare moratorium for prohibiting all of the following, namely the institution of suits or continuation of pending suits. So till that happens, my lord, this suit, my lord, there is no bar.
Yes.
My lord, it can, my lord, continue, and that is the correct position in law.
Correct.
Because, my lord, 9, my lord, gives me a right to come to a civil court unless there's an express bar.
Yes.
Moratorium recognizes, my lord, that the bar envisaged, my lord, only comes in, my lord, after, my lord, an order of admission. My lord, so, my lord, my first respectful submission is,
Not admitted.
today, my lord, there is no bar. This court, my lord, has jurisdiction,
Yes.
my lord, to decide on these issues. Now, my lord, the two cases, my lord, which have been cited, my lord, the first, my lord, of my lord Mohammed Enterprises, Tanzania. My lord, kindly have a look at, my lord, what had happened here. My lord, number one, my lord, is, my lord, I'll just show the paragraphs, but two things your lordships kindly note. My lord, number one, there had been an admission of, my lord, the company petition. After admission, my lord, a resolution plan, my lord, had been approved. Now kindly have a look at section 31, my lord, of, my lord, the Insolvency Code. Kindly have a look at section 31, my lord, of the Insolvency Code.
Approved from.
Yes. If the adjudicating authority is satisfied that the resolution plan as approved by the Committee of Creditors under subsection 4 of 30 meets the requirements of so and so, it shall by order approve the resolution plan, which shall be binding on the corporate debtor and its employees, members, creditors, including etc., to whom a debt in so and so. And it's a, my lord, proceeding in rem. My lord, once, my lord, the approval happens. Now, my lord, kindly have a look at paragraphs 2 and 3 of this judgment. These appeals under Article 136 are against the judgment of the High Court of Karnataka, exercising power of judicial review. My lord, 226 and 227 wasn't a suit, my lord, before, my lord, admission.
Yes.
Interdicting corporate insolvency process, culminating in the acceptance of a resolution planned by the committee in minutes of meeting. In this batch of matters, there are 3 appeals, one by successful resolution applicant, the other by the bank comprising committee, and third appeal by so-and-so. Short facts are, corporate insolvency resolution proceedings were admitted against the corporate debtor at the instance. So, my lord, this is after, my lord, and, my lord, admission, my lord, of, my lord, the insolvency process. Now, my lord, kindly have a look at, then, my lord, 2024. My lord, the next case, my lord, 242 company cases 700, which is 2023, SCC Online Delhi. My lord, 8009, kindly have a look at the first paragraph.
Yes.
My lord, kindly see, my lord, present suit has been filed by the plaintiff, who is a member of the erstwhile board of directors of Chandigarh Overseas Private Limited, which has been admitted into the corporate insolvency process. Again, after admission.
Yes.
My lord, these cases, my lord, with the greatest of respect, my lord, have, my lord, no application at all. Now, my lord, as on date, my lord, without, my lord, an admission, my lord, of, my lord, this proceeding, my lord, can, my lord, if I may put the question to myself, can, my lord, the, my lord, adjudicating authority, which is the National Company Law Board, under, my lord, the Insolvency and Bankruptcy Code, grant any of these reliefs?
No.
My lord, answer is an emphatic no.
No.
On the face of it. Now, my lord, the next is, my lord, that, my lord, by virtue of, my lord, the reliefs which are being asked for, my lord, there is, my lord, a restraint of proceedings. Now, my lord, with the greatest of respect, my lord, that is not so. And in any event, your lordships can make it clear, my lord, that will not stop any proceedings available in law. My lord, that's, my lord, very clear. And, my lord, in fact, my lord, the two cases, my lord, Cotton Corporation and, my lord,
Following.
my lord, Cotton Corporation, my lord, kindly have a look at print page 5. My lord, there was a specific prayer. There was a specific prayer. My lord, United Industrial Bank, my lord, had, my lord, sought, my lord, relief against Cotton Corporation. Now, my lord, kindly have a look at, my lord, in the, my lord, print page 5, last 6 lines. In this suit, the bank took out a notice of motion seeking to restrain by an interim injunction the corporation from enforcing any claim whatever in any form, or from relying on or giving effect to bills of exchange or hundis involved in the dispute for the purpose of so and so proceedings, including winding up proceedings under Companies Act against the bank. Notice of motion also included a prayer for an interim injunction restraining defendants in any manner whatsoever from either endorsing or negotiating or transferring the bills of exchange so and so to take custody and hundi so and so. An ex parte ad interim was granted.
Yes.
Where, my lord, there is no such prayer here at all.
Yes.
And my lord, today, my lord, in any event, my lord, as my lord, I'm not, my lord, here, my lord, to, my lord, advise my learned friends, clients, my lord, but as on date, my lord, I don't know about other proceedings, my lord, there is no competent proceeding today. My lord, it's not even been numbered, let alone admitted. My lord. And my lord, the same, my lord, situation here, my lord, para 52 onwards, my lord. So, my lord, in my respectful submission, my lord, there's really, my lord.
May I take, my lord, 1 minute?
Yes, yes.
And my lord, only one thing I want to say, my lord, my learned friend complimented, my lord, us, my lord, on our research, my lord, he said, my lord, that's why he allowed us. My lord, it's not that they haven't done research, they've also done.
My lord, may I just clarify the point? Point, my lord, is this. Lordship is considering whether there was a default or no default. The event of default is being considered. The event of default, my lord, on the insolvency code, once I filed, my lord, the application, is, my lord, exclusive domain, my lord, of the adjudicating authority under, my lord, the company law and the insolvency code.
But unless it is not admitted, how you can say that?
But, my lord, they have to consider the question of admission. My lord,
Consider if it is admitted,
my lord,
it's
that
okay.
cannot be prevented.
No, that cannot be. That's why they are not asking for preventing you to initiate
But, my
any
lord,
action.
Lordship cannot give a finding which prevents that, my lord, adjudication
That
going on.
cannot be.
That's, my lord, that's the point, and, my lord, that is a legal proceeding already started, my lord, by respondent number 1.
No,
Yes, so
that is
can't be
your
restricted.
file. Your file when it started, it is to be admitted by the.
That has to be considered on the merits of that case.
Correct.
Lordship's order, my lord, cannot prevent consideration of
That's
that matter on merits.
that this court will take into consideration. That will get.
But prayer, my lord, is indirectly asking for that. Because that's a default I'm alleging before the company law tribunal. So, my lord, what is, my lord, directly can't be done, my lord. Indirectly, they want that can't be considered. That is something, my lord, which lordship cannot grant. That, my lord, they have exclusive jurisdiction of the NCLT, my lord, to decide that question, whether default or no default.
And second thing, once there is a penalty clause and they are paying the penalty, how you can say that the total
But that's a matter of merits. I have not answered the merits at all.
If a merit, then it has to be decided during trial.
No, but that's the point, my lord, which they can agitate before, as in their defense. But they haven't yet, they have a chance to be heard. All that I'm pointing out is, my lord, the hearing must go on, my lord, before the tribunal and not before a lordship. That's a jurisdiction point. If I want to answer the merits, I can on affidavit. So that's later on.
You can answer them on merit, no problem. I have to hear the interim injunction at this stage. Because I thought now Mr. Mukherjee has given the reply to your jurisdiction, so let me decide on this point, and on merit also you can argue that.
Yes, that you can do, but after your lordship, my lord, whenever lordship wants, we can.
Or they can file affidavits, my lord, and my lord.
That is different. That is subsequently. Now
No, we'll file. I'm not saying lordship dismiss the suit today. I'm only, my lord, contesting an interim order.
Correct.
That's all. I'm not asking for a dismissal.
A forum has to be open to me.
No.
Today they can't grant any relief. My learned friend
what
not
about the
disputing
interim
that.
order at this stage?
I'm saying, my lord, question, my lord, interim order can't be granted. That's the only question I'm answering. Lordship will consider that point.
Oh.
Well, I'll take 5 minutes, my lord. Your lordship, your lordship may hear me now or at 2 o'clock, whatever it's.
How much? 5
minutes.
No problem.
Well, please see section 63 once of the IBC.
Lord, may I have your lordship's leave?
With section 63, let's please see the language. No civil court or authority shall have jurisdiction to entertain any suit or proceedings in respect of any matter on which the National Company Law Tribunal or the National Company Law Appellate Tribunal has jurisdiction. Now, my lord, what is our case here? Our case here is that, my lord, you are proceeding or, my lord, threatening to proceed against my pledge shares. You are threatening to proceed against my mortgage properties. Now, my lord, the question of pledge or the question of mortgage cannot be decided with the NCLT. My lord, that will have to be decided either by the DRT or, my lord, by a civil court. My lord, now the prayer in our suit is for declaration. NCLT cannot pass a declaratory relief. Now, my lord, the question is, my lord, NCLT petition is pending, my lord, hearing for admission. Let us contemplate. In the meantime, my lord, let us say, my lord, it will be numbered and then it will be considered whatever it is. It is not born yet. But, my lord, even if it were to be born, the question is very simple. My lord, today, can they, my lord, go to the DRT and seek, my lord, to take proceedings against me under the Securitization Act, saying that I've created security? Now, my lord, so far as that is concerned, my lord, that, my lord, has nothing to do with the NCLT. My lord, enforcement of mortgage, enforcement of pledge. My lord, again, my lord, they can go to the DRT and say, my lord, I'm enforcing the pledge. My lord, the question is, my lord, I'm not seeking to restrain a proceeding. I'm seeking a declaration here. And that is exactly what my prayer is. That, my lord, the invocation is wrongful. Now, my lord, today, can I not, my lord, seek such declaration? That, my lord, you are in violation of your contractual obligations and you are wrongfully seeking to invoke, my lord, the corporate guarantee, the personal guarantee, and the pledge, which you have clearly threatened. Now, the question is, how does it then, my lord, fall within the jurisdiction of the NCLT?
Yes.
If the NCLT cannot decide on declaration, that is, my lord, my first prayer in the suit. My lord, the suit prayers have all been set out, my lord, in the application here. Your lordship will find all those prayers at page 57. My lord, please see, my lord, have I sought restraint of legal proceedings? Decree declaring that the letter dated such and such, and my lord, I've said all the letters are void, illegal, non-est. Why do I say that? Because, my lord, section 55 clearly says that if time is not of essence, you cannot avoid. You have purported to avoid. So I'm seeking that declaration and injunction restraining them from giving effect to the notices. That is prayer E.
Yes.
My lord, declaration, perpetual injunction, my lord, consequent on declaration.
Yes.
And, my lord, this is all ultimately, my lord, not with regard to the loan. I'm here, my lord, before your lordship, my lord, seeking this protection in respect of the security properties, which cannot be the subject matter of consideration by the NCLT.
Okay.
Now, my lord, so far as this matter is concerned, this has also, my lord, received the consideration of, my lord, in so far as DRT is concerned, similar, my lord, release were available. Please see, my lord, just one judgment.
May I submit this, my lord? Without prejudice, my lord, we'll answer the merits also, right? Let it not be said we have no answer on the merits. My learned junior will do it. If your lordship keeps at 2 o'clock, my lord, he'll give the answer.
My lord, may I just show this, my lord, two paragraphs? My lord, I'll not trouble your lordship beyond
Let
this.
it not be said, my lord, we had no answer on the
No,
merits.
no. I am not.
That means we were not contented that we had no answer on the merits.
No,
My lord,
that's,
paragraphs
if
85
you
and
want to give
86.
the answer, there's no problem. This court will hear you also.
I'm sorry, what?
There is no problem. I will hear you.
No, that's
also.
not
Married, there is
let
no
it not be
problem.
said, my lord, that we did not answer
That's
on the merits at all.
Because you have raised the maintainability point, I have argued that
Yes, yes.
this court is of the view the matter has to be
I'm not
decided.
saying this suit can go before NCLT. That's not my submission.
Okay.
My lord, kindly see paragraphs 84 and 85. 85 and 86, I'm sorry. My lord, here it was a question of, my
84
lord,
and 86.
85 and 86, I'm sorry, my lord. Question of the jurisdiction of DRT. DRT has exclusive jurisdiction. That was the contention here.
Our industry.
My lord, please allow me to just place these two paragraphs. If the tribunal was to be treated to be a civil court, the debtor or even a third party must have an independent right to approach it without having to wait for the bank or financial institution to approach it first. The continuance of its counterclaim is entirely dependent on the continuance of the applications filed by the bank. Before it, no declaratory relief can be sought by the debtor. It is true that claim for damages would be maintainable, but the same have been provided by way of extending the right of counterclaim. The Debts Recovery Tribunal cannot pass a decree. It can only issue recovery certificates. The power of the tribunal to grant interim orders is attenuated with circumspection. Concededly, in the proceeding before the Debts Recovery Tribunal, detailed examination and cross-examinations, provisions of evidence, as also application of other provisions of CPC, like interrogatories, discoveries of documents, need not be gone into. Taking recourse to such proceedings would be an exception. Entire focus of the proceedings before the Debt Recovery Tribunal centers around legally recoverable dues of the bank. My lord, here, my lord, what the court said was that I can't, my lord, approach the NCLT myself for a relief of declaration. Well, I can only approach a civil court for a relief and declaration. And what is the declaration proceeding? Not injunction restraining them from proceeding to file any suits. I am seeking a declaration that these notices are void, and this is notices are void because they have been issued. Well, in derogation of A, the terms of the loan agreement, and B, in derogation of the statute. So, there is nothing which falls within the jurisdiction. Now, the second part is, if it were to be admitted, then section 14 would become applicable. And if today a resolution plan is to pass, then all creditors, all lenders, everyone, all stakeholders become bound. But that stage might arise after 2 years. After 3 years, I will contest the proceedings. The proceedings will go on. There is appeal, there is Supreme Court. Well, in the meantime, will I expose myself to these harassive tactics and the threat of my pledge being invoked and my properties being taken away?
Okay.
Well, that is my respectful submission before your lordship.
Just make one submission.
Yes.
As of today, there it's not been shown there is any bar. Because there's no proceeding which is pending also. And as of today, if I have a right, which is what we have tried to show, we must have a remedy. And no other forum has been suggested.
That's why I told Mr.
Correct.
Sarkar, you can argue the matter
Yes,
on merit.
yes. I'm
Let
great.
the court decide whether
Absolutely.
it is.
I'm grateful.
When?
2 o'clock today, or I don't know, whatever is convenient.
2 o'clock, my non-commercial matter. Monday?
Monday, is a bad day, I'm told.
Monday is a bad day.
Oh,
Monday is a bad day.
So, I don't know whether we'll.
Okay.
Any other day not convenient to lordship and my learned friend.
Tuesday, देखो कुछ है क्या? Tuesday? Tuesday? क्या? 11:30 से है?
No further, at least the pledge and that I'm sure it won't be.
Sure, they will not take any further
Steps, that shouldn't be.
Today and Tuesday,
No, I hope.
asking. I don't know why my learned friends are agitated. We have done nothing all this time.
No, that's I hope that's
Even
Okay,
if
Monday.
Mr. Sarkar says
Monday
so,
first
then-
matter I will take.
I'm sorry.
Monday first Tuesday.
Tuesday is all right.
Tuesday first matter I will
Yes.
take because from 11:30 other matters are fixed. By 1 hour you will come.
Yes, we will not take that.
Counsel for the plaintiff have concluded their argument. Counsel for the defendant number 1 and 2 argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 22nd July at the top.
Just all right.
In the meantime, it is expected that no, my lord.
No further,
We will be here.
taking
If
steps.
something happens, my learned friend can tell your lordship.
No.
The pending matter, things can be reversed. I don't know why my learned.
No, it's no question. Pledge shares, are sold, then it can't be reversed.
Thank you.
Great.
Contempt,
Commercial or non-commercial?
contempt specially assigned. Non-commercial. Only difficulty, my lord, kindly see, my lord. I mentioned this earlier, and lordship, on 3rd April, the initially it appeared before your lordship's court. My lordship said that I will not take up the matter because the regular bench is before another judge, honorable judge. Thereafter, my lord, the other honorable judge has said that did not take up the matter, and now it has been assigned before this court. I mentioned it on 19th of June, and lordship will be pleased to fix it on.
Why this matter has come before this court?
No, it is specially assigned because the first order was passed by this court.
Which matter?
My lord, item 41. Order dated, order under contempt is 7 July 2023. 41. And lordship on the last occasion was pleased to appreciate the urgency and fixed it at the top on 27 June. But after that, Manal, this court was not available because lordship was sitting in the circuit bench. So that day the matter did not appear in the list. No, I was only praying, Manal, this is at the new motion stage. This will be, that's not moved for the first time on merit. Because lordship said that on first day lordship not be able to take it up. Because
The contempt application.
Contempt, but it is. Now I was only praying, my lord, if I can get a 10-minute window any day next week, my lord. There is no other side because it moved for the first time. Either Friday 2 p.m. or any 10-minute window any day next week, my lord. 2 p.m., 2:33.
Oh, next week, man.
Page 41. It is at page number 56.
25th. खाली एक ही contempt है ना? ऊपर कर।
Lordship is keeping it on
25th.
at the top or at the time, any indication?
2 p.m. See the list.
2 p.m.
Where you will find the
Good.
place.
Good.
Yes, next.
My lord, may I have your lordship leave to mention?
Which number?
42. My lord, pursuant to your lordship's direction, again I have served notice to my learned friend.
ये कोई डेट है आर्ग्यूमेंट का?
This is the last order, my lord. Last order.
तो भाई कोई डेट है? 12th अगस्त व्हाट टाइम? खाली है? 12th अगस्त क्या दिन है? Tuesday. 12th August 3 p.m.
May I have a lordship leave to mention this matter, lordship. I appeared in the morning. Kindly allows me to appear virtually. This is regard to item 22.
Item number 42. Learned counsel for the plaintiff submits that the matter is at the stage of argument and prayed for fixing a specific date and time. Accordingly, let the matter appear on 12th August at 3 p.m. as a specially fixed matter.
3 p.m. fixed, my lord.
Specially fixed matter at 3.
My lord,
Yes.
may I be permitted, my lord. With regards to that, my lord, item number 29, that my lord 283 matters, my lord. My lord, appeal has been fixed on 28th of this month.
28th. 8th of July.
So, my lord,
fixing in the last week of August.
yes, that would be better.
Item number 29. 29. Counsel for the petition submit that the connected matter and in the connected matter, an appeal is pending before the appellate court on 20th August, 28th July 2025. In view of the submission made by the counsel for the petition, let the matter appear on 22nd August. Yes. Yes.
May I have a lordship leave? Your lordship, this is regard to item 22, your lordship.
22.
Yes, your lordship. This matter was heard by your lordship when your lordship had the determination at the ad interim stage. Your lordship was pleased to.
But I am telling you, this is wrongly. My court officers are recorded as a part heard. When the part heard, so it automatically it will be. I am not passing any order.
Subject to correction, my lord, there is an order passed by your lordship, my lord, where it is recorded, my lord.
That's why. So it was disposed of. I passed an order, but
And
my
in fact-
officer is continuing with the part heard.
Your lordship, in fact, the coordinate bench is
Already passed.
hearing the other GA.
If the order is passed, what remains the part heard?
My lord, GA1 is not disposed of. my lord.
GA1, I am part heard with regard to the ad interim order. That order was passed.
Yes.
You are challenged before the appellate authority. So what remains before this part heard?
They had challenged, yes.
Then
Grateful, Your Lordship.
so they list they will take up the question.
Your lordship's pleasure, my lord, not to hear GA1 in full.
Your Lordship, it is fixed in
Unless
a
assign, how we can? I have no assignment. Where is the determination? Parted, that's why you shown, the court officer has shown me.
Yes,
The
my
order is
lord. I have
disposed of.
seen an order where.
So that was disposed of. Yes, next.
I am grateful.
Yes.
But may it please your lordship, I beg to appear on behalf of the petitioner. But we have been served with a GA application now.
Yes.
Now, my lord, the returning officer, my lord, purportedly the returning officer has filed an application seeking deletion of the name of the returning officer from the array of parties.
I will decide at the time of hearing of the matter.
My lord.
I will decide at the time of passing the final judgment.
My lord.
No problem.
Because
Let it
their
get
written
with the
statement is
record.
already on record.
This applicant, because this is this case is at the stage of evidence. If they will close today,
Final arguments, my lord.
then I will fix the argument. Then
Fine.
it will be decided at the time.
My lord.
If you want to argue the matter, I will argue. I will hear you, subject to cost of rupees 1 lakh.
No,
That is yours.
My lord, lordship is deciding that this will be decided at the time of final hearing.
That's why. If you want that it is to be decided at this stage, I will decide it subject to payment of cost of rupees 1 lakh in the State Legal Service Authority. Show the slip, then I will decide.
I cannot file it. I have submitted to the other side.
It's continuing since the first day.
Problem is that
Problem.
There can be filed because there was a by-election and that was the problem.
There is a provision, but now at the last stage of the suit, you cannot come with one and another. Okay, I will decide at the time.
But it has been, my lord, already decided that, my lord, the suit is proceeding ex parte against all the other respondents, save and except the respondent number 15 and 16. That, my lord, has the effect of a decree, my lord. I'll answer, my lord, in the event, my lord, they take that point, my lord. And what has happened is, my lord, on one hand, my lord, this returning officer, I say, first of all, my lord, this is not the returning officer who has filed this application. I'll be, my lord, making submissions, my lord, for initiating perjury proceedings also. Because someone else has come up and describing, my lord, himself as the returning officer.
That is see. Acha, then who is the respondent number 16?
16, my lord, I appear.
You. So you will cross-examine the witness?
Yes, yes.
My lord, cross has been closed. On the...
No, that is the cross-examination.
Yes, yes.
No, that will be closed.
Oh, cross-examination will be closed,
to cross-examine the plaintiff witness on the next date fixed.
Yes,
Because I am fixing a date.
Yes.
For cross-examination, let you cross-examine. If you cross-examine, then this application will become infectious. Then you got the three-way.
My lord, my instruction is that we want to cross-examine.
You want to cross-examine. So why you file this application?
But kindly record that, my lord, the submissions.
Take your decision. If you want that, I will allow you to cross-examine. Then I will dismiss as become infectious. Because you want to cross-examine.
Lord, in that event, I have to take instructions.
No, so
This is a dilatory tactics, my lord, because what they have done is, my lord, they have now, my lord, got some persons from their constituency filed a writ application.
Because
for an election, my lord, upon the
this
ECI.
court has passed an order recording your submission and given a one chance to cross-examine. Otherwise, the cross-examination will be closed. So
Yes.
today, not fixed for
Yes,
cross-examination.
to be mentioned.
So I will fix the date for cross-examination. In the meantime, you take the instruction, you cross-examine or come with the no, you will not cross-examine, then this application will be decided.
Very
on
well.
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Full stop. By an order dated 8 May 2025, this court has granted liberty to the respondent number 16 for cross-examination of the plaintiff witness number 1. But this court finds that the respondent number 16 has also filed an application being EP3 of 2024, praying for deletion of name of the respondent number 16. Respondent number 16. Full stop. The concept for the respondent number 16 press for submit that he will cross-examine the witness. On the other hand, he press for taking instruction whether the respondent number 16 intends to cross-examine the witness or to pursue with the application filed for deletion of the name. In view of the above, for the interest of justice, the case is adjourned. Give the date for cross-examination.
I'll be praying for a very short date.
Really, short date नहीं है. 3:45 कुछ है. 12th August.
But I can't even prepone the date. But it can be posted by next Friday.
That is the problem.
What they're doing is now they have got hold of some people from the constituency. They have moved a writ petition, but praying for declaration of election.
Let it be on 12th of August. That's not far away.
I understand, my lord, the person who has filed an application seeking deletion, my lord, will not be having any say in so far as the date is concerned.
24?
24
तो कल है. 24th July. 24th July. You take instruction on that.
Lord, it's such a short span of time. My instructing advocate says, well, it's difficult to get the instruction. Let it be on 12th of August.
My 8th of May was the last order which was passed, my lord. It was a peremptory order, my lord.
एक काम करो. 1st of August at the top.
1st August. 1st of August.
1st of August at the top at 2 p.m.
But 1st of August,
Yeah,
but
yeah,
I have
problem.
a matter posted in the Gangtok High Court. But kindly take it up on the 25th, 25th.
25th, other there is some 25th.
Any day prior there to subject to the convenience of the honorable.
You do one thing. 24, I am fixing a 3:45. You take instruction if you
Yes.
want to cross-examine. If you
My lord is fixing it on
24th at 3:45.
at 3:45.
3:45. Take instruction. And 24th of July at 3:45 p.m. for cross-examination of the plaintiff's witness by the respondent number 16. Full stop. It is made clear that on the date fixed, if the defendant respondent intent that he will cross-examine the witness of the plaintiff, the application will be dismissed. The application filed by the plaintiff will be by the respondent number 16 will be dismissed. And if the respondent number 16 intend not to cross-examine the witness and pursue the application being EP3 of 2024, the said application will be decided at the time of final argument of the suit. I have made it clear so that yes, you take instruction.
Item number 2, Your Lordship, I am for the plaintiff.
Item number 2.
I am for the defendant, Your Lordship.
Yes, why to be mentioned?
Yes, Your Lordship. May I just indicate why this particular matter actually has been referred by the department before this honorable court? That the suit for partition, Your Lordship, filed by 4 sons in connection with the properties of the father. Now, after the filing of the partition suit, the parties settled the dispute and filed a compromise decree, terms of settlement before the honorable court. On the basis of the terms of settlement, the honorable court passed a decree in terms of the terms of settlement. Now, in the meantime, what's happened? Earlier, Your Lordship, what happened? Your Lordship, that consent decree is required to be registered as well as properly stamped as per the West Bengal's Stamps Act. Now, in the meantime, the Honorable Supreme Court passed a judgment wherein, Your Lordship, the Honorable Supreme Court clearly said that if there is a pre-existing right in the property, then you are not required to do it. But if you create a right in that particular property, then only you are required to register that particular consent decree as well as you have to pay the proper stamp duty. That means what? Your Lordship, suppose there are joint properties of 4 brothers and they want to divide it for allocation of each other. Yes, it is permissible. But here in this particular case, what happened? The father was the owner of the property, and thereafter, Your Lordship, as per the succession, the 4 brothers, Your Lordship, succeeded that particular property. But only for the demarcation or distribution, we came before the Honorable Court. Right has already been created. And then after, Your Lordship, we approach the Honorable Court. Now, the question arises, the department has raised a question that whether this particular consent decree is required to be stamped and registered or not. So, for that, Your Lordship, the matter has been referred before Your Lordship. Only one thing, if may Your Lordship indicate, and subject to what Your Lordship thinks fit, if Your Lordship kindly sees the plaintiff ones, because there is a direction upon me to file and supplementary affidavit showing that it is a pre-existing right, And now whatever the documents we gathered.
Relying upon the Madhya Pradesh judgment.
Yes, Your Lordship. I have also handed over. Your Lordship kindly takes the first the plaint. Lordship kindly sees the cause title once. All are sons of Umya Shankar Chhaganlal Dave. Now, Umya Shankar Chhaganlal Dave, he expired, Your Lordship. That is mentioned. Paragraph 3. Para 3, on 17th of October 1999, Umya Shankar Chhaganlal Dave expired, leaving his wife, Shantaben Dave, and 4 sons, plaintiff and the defendants herein. So therefore, 1999, Your Lordship, the right has already been created. So by way of this particular partition suit, no further right, Your Lordship, is only for distribution. Now, if Your Lordship kindly sees, the properties are mentioned in the schedule properties. Now, I have, Your Lordship, prepared a supplementary affidavit, Your Lordship, as per Your Lordship's direction, only to show Your Lordship that the copy. Lordship, kindly take page 10.
Yes.
Page 10, Your Lordship, is the death certificate, wherein it will be evident, Your Lordship, on 17th of October 1999, Your Lordship, the person expired. Now, page 11, Your Lordship, again, Shantaben also died, Your Lordship, on 12th of April 2011. Now, Your Lordship, I have given Your Lordship all the details wherein, Your Lordship, the properties, Your Lordship, were in the name of Umya Shankar Dave. Lordship, the first deed.
Property is purchased by Umya Shankar.
Umya Shankar.
During his lifetime.
Yes, Your Lordship. I am not, Your Lordship.
What is the date? 1993.
93.
Correct.
Now, Lordship kindly sees the second, this is annexure B. Now, Your Lordship kindly sees annexure.
Where is the schedule?
Yes, Your Lordship. May I just match with the schedule? Schedule A.
Page 22.
It is schedule A to B ta ber karo. Report it. 27A. Lordship kindly sees page 27, that is a tax receipt.
No,
for a
in the
document.
deed. In the deed, where is the schedule?
Lordship, deed. Deed, Your Lordship, kindly see the schedule.
Page 23. Page
Yes, page 20.
Page 22 is the schedule A and page 22.
Yes, page 22, Your Lordship, is the schedule A.
And your schedule is page 14 of the plaint.
Page 9, Your Lordship, kindly sees.
Page
Schedule
9
A.
of? Page 9 of?
Page 9 of the plaint.
The plaint. Yes.
Tarpor ekta bolo.
Flat number 18. Second floor, southern building.
Now, page number 27A, it a B. Now, Your Lordship, kindly sees page 27A. Prior to that, Your Lordship can also see page 27. Your Lordship, the property tax already in the name of Umya Shankar Dave. Now, page 27A, that is in connection with Schedule B property.
No, schedule A property, page 9 of your plaint.
Lordship.
Corresponding to which property of the purchase?
Lordship, that is Schedule A. The Lordship, annexure B. Page number 12.
Page number 12 of?
Of supplementary affidavit. I'm just trying to match it, Your Lordship, with the schedule.
12. That's why. Page number 12 is the deed.
Yes.
And kindly come to the schedule is mentioned as page 22.
22.
Correct. Schedule A. Page 22 is the schedule A.
Yes, Your Lordship, 18 kathas of land.
18 kathas of land.
Flat number.
Where is that?
Yes, Your Lordship, page 24, schedule C. Page number 24, Your Lordship, is flat number 18.
Flat number 18.
Is matching with Your Lordship, page number 9.
9 the so. 1250 square meter. Yes. Yes.
So one has already matched. Now your lordship kindly sees
B property.
B property.
Schedule B.
Agricultural land.
Yes. Lordship schedule kindly match with page 10 of the plant with 27A.
27A.
Correct. Agricultural land. Page 10 with 27A, that is the agricultural land at Murad.
27A. Of the
27, your lordship. 27.
Supplementary.
Yes. Okay. Yes. And your lordship will get page 14 is the agricultural land schedule F.
Where? No. Schedule B, which portion? of the
Schedule B.
27A.
This is house property.
Follow. Piece of land at measuring 127.6 square meter together with house brick built house.
Page 54 your lordship kindly sees. ठीक बोलছো তুমি? Page 50. Lordship can also see page 50. Murad assessment, your lordship. Property number 160, page 50.
Correct.
পরেরটা বের করো।
উমাশঙ্কর জঙ্গল।
পরে কত?
Yes. Page
Now,
50.
yes, page 11 can be matched by page 52. পরেরটা বের করো।
Page 52.
Yes, page 52. Your lordship kindly sees the property number will be matched 162.
Yes.
Page 11 can be matched with page 52.
Yes. Yes.
The schedule D টা বের করো।
Then D. There is the D property.
हाँ। 52 factor है।
How the D has come to the
D, your lordship, is the flat and E is your lordship the self-contained flat at the back side. এটা কোথায় হবে? Page 54, your lordship. 54 and 56.
Where it is?
Page 54 and 56 is the schedule D and schedule E property.
Where?
Lordship kindly sees page 54.
Correct.
Your lordship,
What
name of
number
the
six?
owner is mentioned.
Name of the owner. Umayashankar. Residence so. Ward number property 6 by 3 by 1. 6 by 3 by 261. It is not there.
property number টা match করছে কিন্তু ইয়ে তো match করছে না।
Not there.
54 and 56. Lordship, in this supplementary affidavit, paragraph 12, Your Lordship, I have.
That's why I'm going
Yes,
through,
sir.
but how the-
Properties mentioned in Schedule D and E to the plaintiff as two self-contained flat, both on the ground floor, survey number 2337 FP, opposite Shastri Bagh, Bank of India, Anand, Taluka. I say that the entire land on which the three-story building is standing was purchased by Umaya Shankar Chaganlal Dave jointly with the three sons, Maneshankar, Umaya Shankar Dave, Yogesh Dave, and Nilesh Dave, being the defendants herein. After purchase of the land, the owners thereof had decided and agreed to construct a three-storied building in which Umaya Shankar will have the exclusive ownership in respect of the ground floor. So I am in concern only in connection with the ground floor, whereas three sons shall have the exclusive ownership in respect of the first and second floor. In such process, Umaya Shankar Chaganlal Dave became entitled to the aforesaid two flats on the ground floor. Upon completion of the construction, these three-storied building, Umaya Shankar Dave had duly mutated in respect of the ground floor flats, which are embarked as property number 6/3/261 and 6/3/262. And that is, Your Lordship, page 54 and 56. Property numbers are mentioned, Your Lordship, in the middle top. Property number 6/3/261, page 54, and 56 is 6/3/262.
But if you have purchased along with your father, how your father's name only appearing?
Only ground floor, Your Lordship. Ground floor is belongs to father.
The ground floor. No?
Yes, Your Lordship. Kindly see own name of the owner is mentioned, Umaya Shankar Chaganlal Dave.
Correct. So where is their share? Where is their property?
Property, Your Lordship, that way is, Your
That
Lordship.
is not the case made out in the plaint.
No, in the plaint, Your Lordship, kindly sees. Schedule D.
Nothing.
No, Your Lordship, in the
only you describe the B and C.
paragraph 2, Your Lordship, we have mentioned that Umaya Shankar Dave during his lifetime owned various properties and money in various bank accounts,
Correct.
both within and outside the jurisdiction.
Now what you have made in paragraph 12.
Yes, Your Lordship.
And the document, if suppose, okay, if ground floor is within the name of the father. This one, where is their shares of the property tax of the same property?
That we can disclose, Your Lordship, because this is only in connection with the ground floor.
So where is this is also not disclosing the ground floor, no? Kindly come to the page 54.
Yes.
It is not mentioning that is the ground floor.
Only property number is mentioned.
Property number is mentioned. And you have tallied this property number in paragraph 11. But
Paragraph 54 and 56, ground floor is not mentioned, Your Lordship.
Then another, what is the other property? D and E.
If D and E is, Lordship, covered.
Problem. Then F.
F to
agricultural land.
F is the agricultural land.
Where is that?
No. Schedule F is annexure E. Annexure E ta ber karo. Lordship, I have given Your Lordship page 7 of my supplementary affidavit in connection with Schedule F property. And annexure I have given at Your Lordship page 62. Page 7, Your Lordship, of the supplementary, paragraph 13. I further say that Schedule F of the plaint is in respect of agricultural land which stands in the name of Umyashankar Chaganlal Dave, comprised of survey number 36, 44, 53, 74, 120, 379, 813, 30, 31 at village Murad, Taluka, Petlad, district Anand. And your lordship, the documents your lordship I have mentioned at page 62. All block numbers, survey number, your lordship is mentioned.
But
And
that
the
is
name,
not-
your lordship.
That is not the Schedule F. Schedule F is the survey number 53.
Schedule, that is survey
53,
number
and 53
53.
is not
And
mentioning
below
in-
that, your lordship kindly sees B, piece and parcel of freehold agricultural land admeasuring 29610, lying situated block survey number 36, 44, 74, 120, 379, 831.
Correct, but A.
Now, lordship kindly take page 68. Lordship kindly take page 68, block survey number 53, your lordship will get it.
How this document is issued by the advocate notary?
Translated.
Lordship, this is a translated copy. Lord, the documents are in Gujarati, your lordship. Lordship, kindly take page 69. Page 69, your lordship, is in vernacular language.
Okay. So 16, only these two.
Yes. 53. Lordship, 53 is mentioned at page 68.
That's okay. But with regard to the only F, D and E.
D and E, lordship, ground floor is not mentioned.
D and E. If the ground floor is not mentioned, if you are telling that the other two floors are in their name, so bring that property tax. This is also the part that.
No problem, lordship, I'll bring. Only in connection with D and E, your lordship, I'll bring.
D and E, because you are telling that.
Yes.
That page 54.
Yes, your lordship.
If it is so, it is ground floor. So where is the property tax of yours? As per your case?
I understood. In respect of the other property tax in connection with other floors, I'll bring that. Yes. I'll bring that. But your lordship, in connection with the legal aspect, your lordship, if your lordship is satisfied, then
that's it. Only I want this.
Oh, I was under the impression that your lordship, the interpretation of section 17.
No, only I want this because as per the Supreme Court judgment says that in the partition suit, the deed is not required to be registered. Stamp duty is not required to be paid if it is the
pre-existing
right.
But I got it.
If it is a pre-existing right, because pre-existing right only you got the right over the property.
Yes,
it is not a transfer. So it is not a transfer, so you need not to pay the stamp duty.
Stamp duty or
That is
registration.
that is the
So D and E, your lordship, I'll satisfy you.
That is a satisfied. Counsel for the you are for the defendant. Counsel for the plaintiff has filed supplementary affidavit disclosing several documents to establish that the property in question, the father of the plaintiff and the defendants was having the pre-existing right. This court has considered the document produced by the plaintiff by way of supplementary affidavit, but the plaintiff has not disclosed the document with regard to the Schedule D and Schedule E of the property mentioned in the plaint. According, counsel for the plaintiff prays for time to produce certain document to establish that Schedule D and E also having the pre-existing right of the father. In view of the above, the case is adjourned. Let the matter of when?
After 7 days,
let the matter appear on 1st of August.
1st August.
Next.
I'm grateful.
My lord, item 4 and 5, I appear for the respondent led by Mr. Shakushen.
Yes.
Your lordship probably had, I had concluded my submission.
Only want to give some reply. Yes,
Well,
Mr.
before Mr. Ghosh's reply, I am for defending number 5. I just have one or two things to say. I have not filed an opposition to this. Well, the thing that really he wants to say, well, he's the eldest of the family now. Well, the company was started by one Amritlal Oja. He had 9 sons. My client is the 9th son. And the provision in the when the interim board was there, the eldest son will be the chairman.
Continuous.
So after 9 or 8 of my brothers have passed away, when it came to my turn to be the chairman,
Then
unfortunately this has happened. Thereafter, it was all being fought out. Then my other brother was alive, who was the original plaintiff. Now, when others had tried to come into this suit earlier, they were resisted by the plaintiff by saying that if you're not a member of the board, you could not have made this. This is only an administration. The heirs cannot come in. Be that as it may, that gentleman died and his daughters became the plaintiffs. Now, after his daughters became the plaintiff, even our client is now quite aged. So we said that let the next generation take over the thing. So next, the sons and daughters who were left, they were added as parties. So now it appears then when they were added as parties, that order of amendment was not carried out at all by the plaintiff. Though she has been added as a party, she did not carry that out and took out this application for review. In the meantime, the suit got dismissed for default or for non-prosecution, and now this review is being made. So, only thing I want to point out, which must have been done earlier, this order they are seeking recall is of August. And on some clerical mistakes that so-and-so is not so-and-so's son, this was known to everybody. And this application has been made nearly a year later, 329 days later. This was known to everyone. There was no excuse for any due diligence to be done, number one. And number two is in October, there was another order and the interim board was reconstituted. And my only grievance in this whole thing is that once we thought the litigation has come to quietus has reached, my lord, and the other is from September last year, I have not been able to get any of my remuneration. I'm retired now. I depend on this 40,000 rupees a month or something. So that has been stuck. So, of course, I'm opposing the review. I want the suit. The suit is already, if the review fails, the suit goes because that is the order of the division bench. So, and in the event the suit remains, my lord, my prayer is that now that there's a full board, then the special officer can be removed and the board should start functioning itself. And if it is the special officer is to be kept, then my remuneration. It's only for the remuneration that I'm making the submission.
Well, I had made detailed submissions primarily on the merit of the review, taken your lordship through each ground and said that kindly see this is not a ground under order 47. Second point, I had shown your lordship from the same order, then in every part of the order your lordship has recorded the correct family tree. I am the son of late Chimanlal. Only one paragraph there was a correction. That is not a ground of review. That is an accidental slip which can be corrected under 152. That also a judgment I have cited. Today they are in reply. I would only humbly beseech, my lord, let them distinguish my judgment. There is no question of over and again, my lord, going on.
No, that's why they want
to. The facts, my lord. This will, my lord,
yes.
I will take your lordship leave, my lord. Kindly, we will file a very short note, my lord, that your lordship will give it. Oblige.
Let Mr. Ghosh complete, then I will fix a date for filing.
Oblige.
No.
Well, 3 points have been argued. One is, my lord, that this is a mere clerical or typographical error. Hence, there is no scope of review. My lord, to that extent, even the decision of, my lord, 2013 8 SCC 320 paragraph 12 to 20 and, my lord, 1999 3 SCC 500 para 6 have been cited. But these are, my lord, simpliciter, my lord, clerical and or technical defects, and review does not lie. My lord, with the greatest of respect, my lord, I leave it to your lordship's good conscience and, my lord, sense of propriety to decide whether this is a clerical or a typographical error, or whether your lordship's order really proceeds on the basis that they are the son and predecessor in interest of these two people. But just for 1 second, my lord, takes the order, my lord, that we are seeking review of. But that your lordship will find in the memorandum of review. But kindly, my lord, come to, my lord, the order in question, my lord, and, my lord, Come to my lord, page, my lord. 6, internal page 6.
Yes.
But the paragraph after the setting out of the prayers. In the present suit, the father of the petitioner number 2 was the defendant number 2. And the mother of the petitioner number 1 was the defendant number 4. No, this is not correct. The name of the father of the petitioner number 2 and the name of the mother of the petitioner number 1 were deleted. Now, my lord, again, my lord, I could have understood this is just a sleep. My lord, again, my lord, paragraphs, page 6, last line. After the death of Chimanlal Oja, his wife Maya Devi Oja became one of the members of the interim board of the management. This is not correct. Maya Devi Oja is not the wife of Chimanlal Oja.
Which
My lord, page 6, last 3 lines. After the death of Chimanlal Oja, his wife Maya Devi Oja.
Yes. Chimanla is, it should be a Guna.
Yes, yes. Now, my lord, kindly see.
It should be Gunwant Rai Hoja.
Yes, so my lord, it is not just my lord that. My lord, who is sought to be transposed? Maya Devi. Maya Devi has died.
Yes.
And lordship is substituting. Now, what is the train of thought? What is the logic your lordship is applying? After that, the death of Chimanlal Oja, his wife Maya Devi Oja became one of the members of the interim board of management and was also made as defendant number 1 in the present suit.
Yes.
Hence, my lord, your lordship kindly goes to the next page. Admittedly, the second paragraph, admittedly, the father of the petitioners were the shareholder of the respondent number 1 company, but also the members of the interim board of management of the company. And after the death of the father of the petitioner number 1, the mother, Maya Devi, it should be Maya Devi.
No, it should be after the death of Gunwant Rai Hoja.
Yes.
Gunwant Rai Hoja, the wife was inducted as a member.
Yes, but my lord has recorded the mother was inducted.
The mother of the petitioner number 1. It
Yes.
is to me after the death of the father of the petitioner, the mother. That is wrong.
That is the. So, my lord, if. Now, last paragraph, as the petitioners were substituted as different number 2 and 4 in the suit, and thus the petitioner shall be inducted as members of the interim board of management in place of Pramod Rai Oja and Srimati Maya Devi Oja. This is also not correct. Now, my lord, may I just stop here for a moment? My lord, kindly see, my lord, I have already made my submissions. We do not oppose, in a sense, my lord, these substitutions. The lordship will, my lord, just clarify this, that they are the persons who are sought to be brought in place instead of, my lord, the
Description is
deceased.
to be correct.
They are brought because their parents were somewhere or the other parts of the interim board of management. My lord, I have no further grievance. And my lord, this contention that he has made, that this has been rectified in the October order, kindly takes the October order, my lord. Page 66 of the affidavit in opposition of Anup Oja, my lord. Subject to correction, my lord. Possibly it's still
9th October order, your lordship. 9th October order.
Page 66.
Page 66 of the affidavit in opposition filed by
GA1?
Anup Oja.
Review.
In the review application, GA1. GA1, page 66.
Yes. Yes.
But here also, kindly see the last paragraph at page 66. Different number 4, Maya Devi Oja died, but she had no legal heirs. That is not correct. Next line, your lordship has corrected. Absolutely correct. One Anup Oja was brought on record being the legal heirs of Chimanlal Oja. But this sentence, again,
Number 4 was a different number 4.
Maya Devi Oja. But she was survived. Now, my lord, kindly takes page 21 of my stay petition, GA1. That is exactly what, my lord, it stated. One of their application, it states. Page 21. I am simply saying, my lord, the page 21
of application
of the stay application. My lord. Paragraph number. It is their application for substitution which your lordship has allowed.
Anup Oja and Bhaskar Oja.
Yes, my lord, kindly come to page paragraph 19.
Paragraph 19 of the same
Paragraph
page.
19 of this application, which starts at page 21, kindly come to page 28, paragraph 19.
Yes.
So the company needs younger generation to come forward to take up. This is not what I am saying. Their application. Petitioner state and submit that they have no objection if all the branches of the members of the then interim board of management are represented in the court appointed board. This also I am saying that on this basis, if your lordship passes the order, I have no problem. Petitioner feels that if the following members are added and are substituted, the purpose will be served as all the branches of the family would be represented. Kindly see A. Gunwant Rai Oja, Mihir and Amit as agreed between. So Maya Devi and Gunwant Rai Oja has two sons, Mihir and Amit. So your lordship's recording in the October order that Maya Devi has also died without a legal heir, perhaps, my lord. And they are not also contesting
Instead
that.
of Mayadevi, the Mihir and Amit.
Yes, but this also reads with my lord paragraph 10 of the same application. It says, my lord, Maya Devi, widow of the Gunwant Rai Oja, and himself as members of the interim board. So, my lord, in substance, my lord, all I am saying is that if your lordship, my lord, today in review, my lord, scope is very, very narrow in a review petition. My lord, it is an admitted fact that the petitioner is not the son of Maya Devi. Lord, if your lordship records that the petitioners have been substituted because they were, my lord, their predecessors were in the board of management, and hence I am substituting, my lord, I cannot possibly stand in the way of one of the petitioners. But the other petitioner, as far as the other petition is concerned,
petitioner number
defendant number 2 is concerned, my lord, I have serious objection, my lord, because, my lord, possibly this was not shown to your lordship, my lord. Stay application, page 19. Justice 10th order. Justice 10th order, 3rd December 2018, on similar grounds. This is kindly see the first line. This is an application by one Bhaskar Oja, son of Pramod Oja, from impleading him as a party in the suit. Kindly comes to the last paragraph.
Yes, you're shown.
Yes, your lordship has seen. So, my lord, today, when a coordinate bench has, my lord, refused to add him as a party, and nothing has changed. Nothing has been shown to your lordship. Why circumstances are different? When your lordship had taken up the matter, possibly no appeal preferred from this order, but possibly with the deepest of respect, I am saying, my lord, I am submitting.
Now, Mr. Sen has argued on this point. He stated that at that point of time, other legal layers were there, interim board was there. That's why this court has not allowed Mr. Bhaskar Oja. Now the situation has changed. Now all the legal layers are not there. Then all the legal layers to come on record. This was the submission.
Yes,
My lord, the plaintiff's father herself was there at that point of time.
This was the submission.
My lord, kindly takes then the order of Justice Soman Sen.
Yes.
What was the application made and what was the finding? Page 19. This is an application by one Bhaskar Oja, son of Pramod Oja, for impleading him as a party in the suit. The original suit was filed against the defendant number 1 and the persons in management. The allegation was that the interim board of management, of which the father of the applicant was one of the members, were mismanaging the affairs of the defendant number 1, and it is in that capacity that the defendant number 2 was made a party. In the suit, the principal prayer is that the interim board of management constituted on the basis of the terms of settlement is void and or a nullity. Recently, the interim board of management has been reconstituted. The applicant is not in the interim board of management. There are no allegations against the present petitioner. There is also no possibility of the applicant suffering any adverse order in the suit. On such consideration, this application fails. However, there will be an order as to cause. So all the angles have been contemplated.
Okay.
Now I leave it to your lordship, my lord, to decide this. I am not saying whether it should be done or not done, but possibly these things were not shown to
I
you.
will take note of.
Yes. And my lord, on this aspect, I only want to one judgment that, my lord, I don't need to cite a judgment that if one learned judge has taken a view on a particular facts, my lord, committee of courts, my lord, and my lord, principles of res judicata will also be attracted, because, my lord, first I am arguing that principles of res judicata will be attracted not only in different suits but also at the different stages of the same suit. One application before Justice Sen, your lordship was deciding another application later on point of time in the same suit. Even, my lord, different stages of the same suit, principles of res judicata will apply. If Justice Sen has decided it on 3rd December 2008 in a particular way, my lord, possibly the issue clinches, my lord, the parties. My lord, may I cite, my lord, 2024 SCC, page 1. Ashul paragraph টা বল। The paragraphs I want to say, draw your attention to are 19, 20, 23, 24, 25, 27 and 28.
Yes.
My lord, kindly, my lord, takes, my lord, paragraph 23.
Yes.
This brings us to the question as to whether a ruling of a coordinate bench binds subsequent coordinate benches. It is now a settled principle of law that the decision rendered by a coordinate bench is binding on the subsequent benches of equal or lesser strength. Therefore, said view is reinforced in National Insurance Company Limited versus Pranay Sethi, wherein this court has held that the two-judge bench in Santosh Devi should have been well advised to refer the matter to a larger bench, as it was taking a different view than what has been stated in Sarala Verma, a judgment by a coordinate bench. It is because a coordinate bench of the same strength cannot take a contrary view than what has been held by another coordinate bench. Then, my lord, 24, the impact of non-consideration of an earlier precedent by a coordinate bench is succinctly delineated in Samand in his book in the following manner. A refusal to follow a precedent, on the other hand, is an act of coordinate, not of superior jurisdiction. Two courts of equal authority have no power to overrule each other's decisions. Where a precedent is merely not followed, the result is not that the latter authority is substituted by the earlier, but the two stand side by side, conflicting with each other. The legal antimony thus produced should be solved by an act of higher authority, which will in due time decide whether the competing precedents, formally overruling one of them and sanctioning the other as good law. In the meantime, the matter remains at large and the law uncertain. Now, my lord, this is regarding, my lord, committee of courts and, my lord, whether it's binding. My lord, other one is the point of res judicata. My lord, kindly may I cite 2025 SCC online SC 1218. Kindly, my lord, takes paragraph 53 to 56. But kindly takes paragraph 53, my lord.
Yes.
The High Court, in its impugned order, had held the application of the appellant under Order 1, Rule 10 to be barred by res judicata and thus not maintainable on that ground. We find no infirmity in the said observation made by the High Court. This court in Bhanukumar Jain versus Archana Kumar, reported in 2005 1 SCC 787, observed that the principles of res judicata apply not only to different proceedings but also to different stages of the same proceeding as well. This is what the law I'm propounding. Well, all these judgments have been referred to. I don't want to waste your lordship's time. But this has been going on from 1987 Supreme Court. But also, my lord,
Yes, anything further?
yes. My lord, on the scope of review, since my learned friend has cited those two judgments, only clerical and arithmetical mistakes can be corrected. May I cite 2000 Volume 6 Supreme Court Cases 224, paragraph 52. Sorry, paragraph 50. Paragraph 52.
Yes.
The dictionary meaning of the word review is the act of looking offer something again with a view to correction or improvement. It cannot be denied that the review is a creation of statute. This quote in Patel Naresh Thakreshi versus Pradyumna Singh Ji, Arjun Singh Ji held that the power of review is not an inherent power. It must be conferred by law either specifically or by necessary implication. The review is also not an appeal in disguise. It cannot be denied that justice is a virtue which transcends all barriers, and the rules or procedure or technicalities of law cannot stand in the way of administration of justice. Law has to bend before justice. If the court finds, this is important, my lord, that the error pointed out in the review petition was under a mistake, and the earlier judgment would not have been passed but for erroneous assumptions, which in fact did not exist, and its preparation shall result in miscarriage of justice, nothing would preclude the court from rectifying its error.
Yes.
That is exactly what, my lord, we are saying. That, my lord, and my lord, last, my lord, paragraph of this same my lord, page 248, rectification of an order thus stems from the fundamental principle that justice is above all. It is exercised to remove the error and not for disturbing finality. When the constitution was framed, to substantive power to rectify or recall the order passed by this court was specifically provided under Article 137. Our constitution makers, who had practically wisdom to visualize the efficacy of such provision, expressly conferred the substantive power of review of any judgment or order by Article 137. This, of course, is on a different footing, and Clause C of Article 145 permit this court to frame rules as to the conditions subject to order. And, my lord, power under Order 40 had been framed overpowering this court to review an order in civil proceedings on grounds analogous to Order 47, Rule 1 of Civil Procedure. The expression for any other, this is what I'm again relying on, the expression for any other sufficient reason in the clause has been given an expanded meaning, and a decree or order passed under misapprehension of true state of circumstances has been held to be sufficient ground to exercise the power. Apart from Rule 40, Order 40, Rule 1, the Supreme, this I am not relying on. So, for sufficient reason has been clarified by the Supreme Court. The expanded meaning and my lord, to correct misapprehensions and true state of circumstances has been held to be sufficient ground. I am saying, my lord, this is not a clerical error. My lord, in the both the orders, possibly your lordship, the true facts were not told to your lordship or were not brought forward. If this remains, it will only end in, my lord, more, my lord, chaos and, my lord, misunderstandings. Your lordship, my lord, has certainly got the power to intervene in review. And, my lord, as far as the last point, that I have not come with clean hands, I have there is delay, my lord. I have filed my application. I have tried to explain. My lord, the review was filed at the very, my lord, first instance. It was only because your lordship had taken the view that you must amend the petition, and that is why, my lord, the dismissal had happened. And in the appeal court, my lord, the appeal court
That's
said
why
that
this court is of the view, because your client or whatever it may be, it has not been properly advised on dragging the matter. That's why this court has the occasion to deal with the suit and to dismiss the
I
suit.
do agree. Now, my lord,
After all this thing, then you have come with an application.
No, my lord, review was there. Review application was on.
No, this was there, but your advocate again and again appearing before this court, not amending the petition.
Because, my lord,
not amending the petition.
That's why I said
then
we are not in the way of amending. But, my lord, the basis of these orders, if lordship clarifies, we have nothing to no further problems.
No, that's I'm telling you.
I have assisted
you have
your lordship.
explained, but
I have
changing of the advocate
should not happen.
Will not change the circumstances.
No. And your lordship sees the client, not who is standing to argue. Lord, kindly takes it from me. It was not the this thing. All we said that if the basis of the orders is clarified, that because their predecessors were in the management interim board, that's why I am allowing. We have to carry out the amendments.
Okay. No.
Those are my suggestions.
My lord, may I be permitted to give a one-liner reply, your lordship? One-liner reply. My lord, Mr. Ghosh has pointed out paragraph 19 of my application, GA 21, my application for addition. My lord, therein, my lord, I have clearly stated that who are the legal heirs of the predecessors. So it cannot be my contention to mislead this honorable court and to add into the, my lord, board by choosing the name of Mahadevi Ojha. That is the first contention. And secondly, regarding the addition, my lord, of Bhaskar Ojha, The defendant number 2, my lord, your lordship has seen or read the order passed by my lord Justice Shoman Shen, which clearly states that at that point of time there were other board members present and the my lord special officer as well. So there was no need for induction of Bhaskar Oja at that particular point of time. But now the situation has changed to this effect that only the client of my senior Mr. Ghosh is present and none of the board members were there, 7 except the special officer. My lord, we said that all the my lord legal heirs of the predecessors of the who were the board members should be there in the board.
Okay. So much. Most pertinent point.
Yes, file the written note.
Yes.
My lord, may we file the written note, your lordship?
The parties concluded their argument. Police the parties are directed to file their written notes of argument. The matter on 25th has to be mentioned for filing written notes of argument.
My lord, by which date we will file our written notes?
Next week, 25th.
25th. Deeply obliged, your lordship.
Number 6.
4 and 5 over, na? 6.
I am from the respondent, my lord, on the last occasion.
I must inform your lordship, my lord, that in this matter, although I had argued, but at present, my lord, my learned advocate on record wishes to argue the matter himself. So, my lord, I am informing this to your lordship.
Who?
Mr. Surinder Singh Bengani.
He will argue.
He wanted to. Mr. Virender Singh Bengani wanted to, my lord, argue this matter himself. So, my lord will kindly not take me amiss. I will not be, my lord. I will
where
not be in
he
a
is?
position. I do not know. I am not completely aware. I am not aware. I'm sorry, my lord. I won't be able to assist you.
He has almost completed his argument. Only one decision to be cited.
And I mean, I think which I cannot make any further submission.
No. I just.
That is with regard to that.
No, my lord, the point was very interesting. It was whether RTGS comes under the. Although I have done good research, I have given it to Mr. Bengani. I'm sure he will be able to assist your lordship.
Mr. Rohit Banerjee, an advocate appearing for the plaintiff, submit that though he has argued the matter at length, but he has instruction that Mr. Bengani will argue the matter further. Accordingly, prays for accommodation. In view of the submission made by Mr. Banerjee, the case is adjourned. Let the matter appear on 1st of August.
I will inform you.
First
I will
August.
inform.
1st August.
7.
Review. E-review.
My review application.
Yes.
To review on a very peculiar ground. Lordship, there were 2 written notes filed.
2
written notes filed. So one before the argument, your lordship, a coordinate bench had asked for. One after the argument. Your lordship, the difficulty that has arisen is your lordship has passed the order considering the written notes filed before the coordinate bench, even before it was argued before your lordship. So I'll just show from the records that error and your lordship why that changes the nature of the judgment.
Yes.
My lord. In any event, if my learned friend wants to proceed, he can, of course, my lord, let the review be heard out, my lord. If your lordship is, the pleadings are complete, my lord. If your lordship is pleased to take up the matter today or any day, whenever it's convenient.
Yes. Pleadings completed.
Pleadings
Lordship,
complete.
after this my injunction application under,
my
under
affidavit
12.
in opposition
Opposition of?
to the stay application filed in the review.
Review application.
Stay application filed in the review.
File the reply. You file reply.
Lordship,
Mother, we have not received the reply.
No, your lordship, we have not even received the opposition.
The service was not made.
Respondent has filed reply, filed affidavit in opposition in connection with GA1 of 2024 after serving the same to the land council for the petitioner. Council for the petitioner, prays for time to file affidavit in reply.
Lordship,
Let affidavit in reply be filed by
Lordship, 7 days. I don't think I need
week. Is the matter on 1st of August.
Lordship, just one request, since your Lordship is keeping it, Lordship may direct the application in which your Lordship has passed the order. Already there, your Lordship. Grateful.
Now, my lord, there's only one difficulty. On 1st of August, my learned junior is in some difficulty. If it can be any day apart.
8th of August.
8th of August. Grateful.
Grateful, Lordship.
May it please your Lordship, Miller. I am appearing on behalf of the review applicant. It will come back to your Lordship, Miller, that in an undefended suit, I was being led by Mr. Dutt. Undefended suit, Miller, dispute with respect to the word commercial dispute. But Order 9, Rule 13, we had, Miller, filed. Your Lordship, Miller, was pleased to reject that application, holding that this was in fact a commercial dispute. Now, this review, Miller, has been formally filed by us to bring on record, Miller, our prayer that the decree, Miller, could not have been passed because it was originally a commercial dispute. So, Miller, today I will be beseeching your Lordship.
That's why their prayer. That's why I not set aside the decree.
Yes.
Order 9, Rule 13, the decree cannot be set aside.
Yes, but we have not preferred any appeal from that order. We bow down to your Lordship's observations. And this review has been taken out after your Lordship was.
What is the point of review?
Miller, the point of review is that and in course of the hearing of our Order 9, Rule 13, the plaint was, Miller, we received the plaint. That is what we are submitting before your Lordship. And Miller, even it appears from the plaint
that was
also
also
commercial. If my learned senior colleague, Miller, wants to use an affidavit, he may, Miller.
No, I will. No,
Yes,
in the Order 9, Rule 13, they have taken the same point. Same point was argued that it is a commercial suit.
Yes, but unfortunately,
which was not accepted by your Lordship. Your Lordship may have observed that thing, but ultimately the application has been cancelled. And moreover, this review application is also not
review of the decree.
Review of the decree,
23rd March,
undefended.
2023.
It's a clear case, Miller, of services which Miller, they say they have provided, we have not paid regarding a construction. So, Miller, it's a commercial dispute.
Delay has not been explained.
Okay,
Miller, whatever affidavit, if directions of affidavit, there is only one application explaining the delay, praying for condonation, and the final reliefs.
But may I indicate only one thing? This was the original system of our High Court in the original site, making combined application. We were in our childhood days, like my learned junior friend, used to follow this practice.
You will not believe when I have given the determination, when I find that the GA order is something in some file and file is somewhere, I ask my court officer why it is so.
So,
they are telling that this
time, Maharaj Justice Altamas Kobir, when his lordship was taking up this jurisdiction, his lordship decided that no, you have to file two applications. One is Section 5, one is stay. And that principle is prevailing for last 30 years.
If that is going to be argued, I'll take leave and file another application. I didn't want to burden the court with one more application. But the prayer is there.
The counsel for the defendant prays for time to file affidavit in opposition. That affidavit in opposition is filed within 2 weeks.
2 weeks.
Within 2 weeks. Reply if any there to be filed.
Not opposition by the plaintiff. I am the defendant.
Achha, you are the defendant. Counsel for the plaintiff prays for time to file affidavit in opposition in connection with GA1 of 2025 in review 10 of 2025.
2 weeks.
That affidavit in opposition filed within 2 weeks. Reply if any there to be filed within 2 weeks thereafter. Release the matter on 22nd August.
22nd.
Yes.
22nd August.
Actually, I'm deeply obliged to
Contempt.
Your Lordship, item number 9, Mr. Krishnadas Poddar is appearing for contempt number 1. I'm praying for not today as he's appearing in another court.
I appear for the Lordship, under number 2 and 3, Lordship.
Kindly grant a short pass over because your Lordship has been pleased to take up this matter several times. 13 June, the whole series of orders made by your Lordship, somebody appears and somebody doesn't appear. This is continuing since 14th of January. So many orders have been made by January.
So the final hearing?
Yes, my lord.
When the
Contempt.
hearing of the contempt application.
My lordship remembers that Howrah property, the contemptor had appeared in the box.
Yes. Where is he? When he will be available?
Your Lordship, he is appearing in court number 25. So,
Last order before.
Okay, pass over.
Kindly pass it.
Pass over.
Okay.
Item number 10, my lord. I'm praying for a short accommodation, my lord.
You are for the?
I'm for the petitioner, my lord.
Why come? Why pass over? Why can't?
There was some miscommunication between the council and our part, my lord.
Not today. Not today.
Not today.
Next.
Item numbers 11 and 12, I appear for the petitioner in this matter. Your Lordship had, by way of my Lord's order dated 13th June 25, issued a warrant of service against the contender number 10, my Lord. This, Your Lordship will recall, is a fresh warrant of service in light of the report that was filed by the police station that they could not identify and get hold of this individual because his father's name wasn't there.
Well, I'm sorry, but item number 10, I appear for the container number 1. It's a contempt. And I was little late.
Contempt number 1?
No, 10, sorry.
Pass over.
Not today.
Not.
No, not today.
Not today.
The petition split for time, not today. So next Friday it will come. Yes, there is a report. This Deputy Sheriff has sent, but there is no report from the Superintendent of Police, Jamui.
We've taken all necessary
They
action.
have received the report, received the materials on 7/7. Today we are on?
We are today on 18th July, my lord.
18th July. We got an order. Only one contempt, no?
There are altogether 10 contemptors, but the order was only against contender number 10 because he's failed to appear before your lordship despite repeated orders of
Against the contempt number 10?
Yes, my lord.
By which order the contempt was, rule was issued?
My lord, your lordship will have this order 13th June. The rule was issued, I'll tell your lordship.
Orders का है?
Lordship will have, my lords, page 15 of my supplementary affidavit in contempt case number 77. This is the order dated 14th January 25, my lord, that your lordships have passed, my lord. Lordship has page 15, my lord. Order dated 14th January.
Page 15 of? See,
Of the
77?
supplementary that I filed, my lord, in the contempt 77, my lord. 14 January, I have order. You know. Yes.
By an order dated 14th January 2025, this court has issued warrant against the alleged content number 10, namely?
Namely, my lord, I'll tell your lordship.
Content number 10, namely, what is the name?
Ajaz Ahmed, AJAZ.
Katua. What is his name?
Ajaz Ahmed, my lord.
Then Rodham, what is?
I'm sorry, my lord.
What is his name?
AJAZ. Ahmed.
Katua.
Yes, my lord.
Then Rodham. What is that?
Son of Mazharul Hassan, village in PO Aksar.
Where is it?
Jamui, my lord.
So this
is your lordship. Your order ticket.
वो नहीं in contempt application ना.
So, my lords, this we've come to know subsequently the address of
You're not amended.
my lords. In that event, what I'll do is, if your lordship could pass directions, and in the interim, I'll make amendments to the address there.
This court by order issued by an order dated 14 January 2025, this court has passed an order issued a warrant against the contempt number 10, namely Azaz Ahmed. अरे बाकी ऑर्डर्स कहाँ हैं? दीजिए.
Application or reply to the our contempt or reply. So,
कोर्ट का पेपर दूसरा कैसे निकालता? कौन है? बुलाओ रजिस्ट्री डिपार्टमेंट को. कोर्ट का पेपर कैसे निकालेंगे? रजिस्ट्री डिपार्टमेंट.
नहीं এটা দিয়ে দাও.
नहीं दिया भाई. क्या बोला? Issued an warrant against the contempt number 10, namely so and so so and so. Full stop. When the warrant was issued, comma a report, एक रिपोर्ट था ना एसपी का जिसमें बोला इसका फादर का नेम नहीं है. ना ये नहीं. Okay, I will pass order.
My lord.
चैम्बर में लेकर सारा फाइल.
Grateful.
Next. 11-12 है ना दो जिसमें रिपोर्ट है मेरे चैम्बर में लेके इसमें ऑर्डर करूँ.
But this is that contempt matter. I have to give reply. It will take some time. Mr. Mitra had completed.
We had completed.
And I had to give reply. But it will take some time.
That did. That did.
Yes. Because Mr. Mitra has argued those points of when the deed exactly is said to be executed.
Point of law he has argued.
Yes. So it will take some time. But if it can be fixed on 1st August, I have spoken to my learned.
As per the prayer made by the counsel for the plaintiff, case adjourned, let the matter appear on 1st of August.
Well, the interim order is extended.
Interim order is extended till 8th of August 2025 until further order, whichever is
Great.
And for the petitioner, contempt application, my lord. Directions were issued for exchange of affidavits. I'm out of time for my reply. I need, my lord, some time to put in the reply affidavit. Lastly, my lord, it was taken up on 13th of June.
Yes.
2 weeks time was granted, my lord, for them to, my lord, file their opposition. They have served us. My lord, I need to file a reply. My lord, 1 week's time is sufficient for us.
For the plaintiff praise for
Could I just file my affidavit?
It is. The alleged counsel for the alleged contempt have filed affidavit in opposition. Let the same be cut with the counsel for the plaintiff praise for extension of time to file affidavit in reply. Let affidavit in reply be filed within a week. This is the matter on 1st August.
Yes. My lord, same order can be passed in 17. Same situation, my lord. I am the petitioner. He is the alleged contempt.
17 also same.
Affidavit 17.
Affidavit filed. Put in the record same.
1st of August. Great.
Next.
Lord, 15. I am for the petitioner in this contempt petition. My lord, by your lordship's last order of 13 June 2025, my lord, the respondent number, alleged contender numbers 1 to 6 were directed to file affidavit of compliance. No affidavit has been filed till date.
Your lordship,
Yes, yes.
And my lord, as far as contender numbers 7 to 13 were concerned, warrant of arrest were issued. But my lord, I am told, my lord, warrants have been issued, but compliance page. Let me I file the is the supplementary.
How many warrant was issued?
My lord, 7 to 13.
Lordship, I appear on behalf of the alleged contender.
Number?
For the alleged contender, Lordship, I appear on behalf of all contenders.
Why there is a warrant? Why you are appearing?
I think she's mistaking the item number because my learned friend is appearing for 1 to 6.
In which matter you are appearing?
For item number 16.
This is a 15, madam. 15.
My lord, the warrant of arrest for 7 to 13 have been issued. My lord, the department, my lord, there should be a report from the department as to what has happened with regard to that. If they're
Yes,
not,
where is our affidavit?
Your lordship, Mr. Banerjee is on his legs before the division bench.
no.
Kindly grant us an accommodation for a week.
No. Mr. Banerjee may be on his legs, and I don't know which Mr. Banerjee. But the directions was to file an affidavit of compliance.
Where is your affidavit? Press for time to file affidavit. Let the affidavit of compliance be filed 2 weeks. Reply if any thereto. Okay, I am issuing the warrant.
Yes, my lord, kindly issue.
By an order dated 13th June 2025, this court has issued warrant against the defendant number, alleged contender number 7 to 13. Accordingly, the warrant of arrest sent to the Superintendent of Police, District Muzaffarpur. Accordingly, warrant of arrest were issued by the officer in charge, Sakra Police Station, District Muzaffarpur, Bihar, on 8th of July 2025, and by the office of the Superintendent of Police, District Muzaffarpur, Bihar, on 9th of July 2025. In spite of receipt of the warrant, neither the warrant was executed nor any report is filed by either by the officer in charge, Sakra Police Station, District Muzaffarpur, Bihar, or by the Superintendent of Police, District Muzaffarpur, Bihar. In view of the above, the officer in charge, Sakra Police Station, District Muzaffarpur, Bihar, and the Superintendent of Police, District Muzaffarpur, Bihar, are directed to submit the report with regard to execution of the warrant received by their office on 8th of July 2025 and 9th of July 2025 against the alleged contender number 7 to 10 within a period of 7 to 13 within a period of 2 weeks from date. Police of the counsel for the petitioner plaintiff is directed to communicate this order to the officer in charge as well as Superintendent of Police for compliance. Let the matter appear to list. The counsel for the alleged contender number 1 to 6. Yes, what is the prayer?
Are you engaged in the matter? She's not engaged. There is no advocate on record. There is no instruction why the orders of court are being taken like this. No affidavit of compliance.
By an order dated 13th June 2025, this court has directed the contender number 1 to 6 to file their affidavit of compliance. But when the matter is called today, no affidavit is filed. Accordingly, this court finds that the contender number 1 to 6 are not interested to file the affidavit of compliance, let warrant of arrest be issued against the let the alleged contender number 1 to 6 are directed to appear before this court in person on the next date fixed. List the matter on
1st August if it commences.
2 weeks. No?
2 weeks the 1st August. That's what I'm saying.
On 1st of August 2025. Next.
Madam, I'm appearing on behalf of the alleged contender.
Yes.
Milord, on the last occasion, your lordship was pleased to allow me an opportunity to file an affidavit in opposition to the report of the special officer. So, Milord, I am seeking for an extension of that time, Milord, because the affidavit would not be affirmed.
Press for time to file affidavit in opposition. The special officer filed the report up to 7 years.
Yes, so I am seeking for an extension of a week, Milord, to.
Yes, somebody was appearing for the contender.
Milord, I am being led by Mr. Kormukar.
He is appearing, Lordship, for the alleged contempt. We are from the same chamber.
Also, Milord, just to indicate one thing, the order that is being complained to be violated of is no more because the appeal court was pleased to set aside the injunction order, your lordship.
So what do you want? You want to withdraw?
I am not the contender. I am the alleged contender. I would like it to be dismissed, but the petitioner is not here. So at least one chance should be given to
counsel for the alleged contender. Press for extension of time to file affidavit in opposition. Let affidavit in opposition filed within 2 weeks. Reply, if any, there to be filed within a week thereafter. List the matter on 8th of August 2025. Next.
My lord, item number 18, my lord, I am for the petitioner, my lord, who has taken out this contempt application.
Yes.
My lord, they have preferred an appeal, my lord, which is also being listed today at court number 37 as item number 8, and there is a stay in that particular appeal of your lordship order. Let that we stand over for some time in the list because that appeal has not yet been heard.
Okay. Record an order. As per Learned Counsel for the petitioner submit that against the order dated 19th of February 2025, the alleged contenders have preferred an appeal, and the same is pending, and the appellate court also passed an order of stay of the order dated 19th February 2025, and the appeal is pending before the appellate court for adjudication. Appeal is pending before the appellate court for adjudication. In view of the above, let the matter go out of the list for the present, liberty to mention.
Item number 19, my lord, I am for the alleged contempt, my lord. And the direction was there to file certain documents with the court, my lord. Time was for 3 weeks, my lord. Thereafter, an appeal was preferred and appeal was lost. My lord, we are ready to submit the documents, but as the time has expired, the registrar has not accepted the documents.
This is that matter with regard to the will. We said that we are the co-executors. Some documents are with the other executor. So my lord,
document is with the beneficiary.
page 57, the list has been given. Maybe lordship has called upon that will. Appeal, yes. And let them
But if my lord extends the time till Wednesday, the documents will be submitted before the registrar. The registrar needs an order extending the time, or else the registrar is not accepting the
come
documents.
before the court. Yes. Yes.
Compliance come here.
Yes. Before the court. Next Wednesday.
But only one thing, the documents will have to be filed in the suit.
Come
That is
here,
why.
come with the document here, then this court will
it's a
find
contempt.
that all documents are there, then I will pass the note on sending the document.
My lord, the documents will be in the sealed envelope as per the direction.
Yes, rule be issued.
No, my lord, I'll comply, my lord. I comply. In a sealed cover, I have it. My lord. I have it. I can come today itself. I can come today itself.
Let the contender present here, and then I will
But
see.
she is an old lady, my lord. I have the documents. I can submit. My lord, kindly consider, my lord. I can submit any day if my lord gives. Any day.
As per the prayer made by the counsel for the alleged contender, the case is adjourned. Let the matter appear on 25th of July 2025. it is made clear that on the date full list of the alleged contempt is directed to file affidavit of compliance on the date fixed. If the alleged contempt failed to file the affidavit of compliance, necessary order will be passed. This is the matter
The
on
date, if the compliance has to be filed, the date has to be extended, my lord.
25th July.
25th.
Yes, deeply obliged, my lord, deeply obliged, deeply obliged.
Item number 20. Next matter.
Yes.
The next matter, if I may mention, you know, the interim order is expiring today. Mr. Ghosh is on the other side. This was that fraud account, bank account after the husband's death. Interim order is expiring today, my lord.
I was in my defense, I was arguing. And then after that, one Friday we missed, and it's any other day, your lordship fixes it for the.
एक डेट देखो.
Does it have to be on a Friday? If it is not, then any day.
I am fixing any date.
Yes.
For July.
Your Lordship, I'm appearing for the respondent number 4 in this matter.
24th July, Mr. Ghosh.
24th July.
3 p.m.
Or
24th.
1 week later. 24th, 25th, we need.
ঠিক আছে 31st চাইছে
Anyway, for the first.
12th August, what time? 3:45. What is the day? 12th August, 3:45. As per the prayer made by the counsel for the parties, the case is adjourned. Let the matter appear on 12th August at 12 and 3:45 p.m. as a specially fixed matter. The interim order is extended till
3:45.
22nd of August 2025 or until further order, whichever is served.
You actually kept it at 3:45, no?
3:40. 12th August, 3:45.
Great.
As a specially fixed matter.
27. May I have the I need to mention the matter for extension of interim order expiring today, mine.
Who is for the other side?
I am for the side. I'm not even number 120.
Yes.
The bank company will order. Lordship, the matter has been taken up so many times, my lord.
Partner है क्या?
हाँ, partner. Partner.
So what do you want? देखो dates देखो. Fourteenth August. And counsel for the plaintiff prays for extension of interim order. Police counsel for the defend number 4. Defend number 4. Defend number 4.
I'm 120.
Defend number 4 raised objects for extension of the interim order. Concern the submission made by the counsel for the parties. The interim order is extended till 22nd of August 2025 or until further order, whichever is earlier. Let the matter appear on 14th August at 3:45 p.m. as a specially fixed matter.
With regard to item number 38. Item
Yes.
38, I'm mentioning upon notice, Mr. Abbas is appearing, the
38.
interim 38.
Yes.
The
I'm for
interim
the
order is
defendant,
expiring
Lord.
today, my lord. This is last order of 10th of June.
I'm for the defendant. I'm for the defendant.
Yes, cafe.
Yes.
Yes, yes.
Cafe. Now, she will fix the matter because they have complied with the City Civil Court's order and they filed the amended plaint. So, there is no appeal from or 227 from that order in City Civil Court. So, you have to hear out the section 10 and my 39 1 and 2. Yes, that has to be heard.
एक डेट देखो.
Yes.
Dear Lordship, the only prayer is kindly fix any date after 28th.
20?
Oh, 20th of this month. 20th of this month.
What time? Counsel for the plaintiff prays for extension of interim order. Full stop. Counsel for the defendant prays for fixing a date and time for hearing of the applications. In view of the above, let the matter appear on when? 18th of August 2025 at 3:45 p.m. as a specially fixed matter. The interim order granted earlier is extended till 22nd of August 2025 or until further order, whichever is earlier.
We are grateful, Your Lordship.
Number 39, my lord. Item
Oblige.
number 39, my lord.
Oblige.
Entry order is expiring today, my lord. I'm for the defendant.
Who is for the defendant?
My lord, Mr. Day is for the
Yes.
defendant.
Not opposing. Acha, that Bahubali.
Oh, my lord.
Item number 39. Counsel for the plaintiff prays for extension of interim order. So interim order is extended till 29th of August 2025 or until further order, whichever is earlier. Let the matter remain in the list. Date fix. क्या देखो date है. Now the commercial court will not get any date. Huh? 9. Extended till 19th August 2025. Leave the matter on 19th August at 3:45 p.m. as a specially fixed matter.
But may I?
43.
Yes.
Who is from the other side?
I appear for the defend. I appear, my lord. 43.
Yes, 43. What is CC? Contempt?
No, Milad, JCC. Commercial list. Sorry. Milad, OCD 43. I'm sorry, Milad. I'm sorry. OCD 43.
43. JCC. Yes. That matter.
My lord, I have filed an application under Section 8 that is being heard. We have concluded our argument. My learned friend is arguing.
Record an order. Counsel for the plaintiff prays for extension of interim order. Counsel for the defendant submitted. Then the defendant has filed an application under Section 8 of the Arbitration and Cancellation Act, and the defendant has concluded his argument, and the plaintiff has to give reply to the same. In view of the above, let the matter appear and give the date.
It may continue in the list.
क्या बोला?
Or Milad can keep it any other day, Milad. I know, Milad. I leave it to your lordships. Right.
In the above, date नहीं है?
No.
Commercial. 14th August.
14th August coming day.
19th August. 19th August at 11:30 p.m. Interim order extended till 11th August.
But may I have your lordship's leave to mention item number 13 of your
19th August.
Fine.
I have your lordship's leave to mention item number 13 of your lordship's commercial list.
Item number
13 of your lordship's commercial list.
13, 1-3.
1-3.
Yes.
Malad Ashirwad Pipes. Malad, the interim order expired yesterday. It was till 17th of July.
Who is for the other side?
Mr. Chatterjee is here. There was no directions for affidavit. I was just praying for directions for affidavit. But my lord,
That's the last order part.
the lordship would kindly allow us, my lord, at least 6 weeks times to file affidavit.
An affidavit?
I tell lordship why. This is
my lord, because my lord, my client is in custody, my lord.
This is the reason. My lord, they want 6 weeks.
My client is in custody, my lord.
Defendant is in custody.
Record. Item number
13
of the commercial. Counsel for the plaintiff prays for extension of the interim order. Counsel for the defendant prays for extension of time. Prays for time to file affidavit. Prays for 6 weeks time to file affidavit in opposition. Full stop. Let affidavit in opposition be filed within 6 weeks. Reply, if any, there to be filed within 2 weeks thereafter.
But may I only, at this juncture, may I only indicate one thing? My lord, in view of the subsequent events, I would be praying for further orders in the application. So if your lordship kindly keeps the matter in the list, affidavits may be filed by the defendant in the meantime. I shall press further orders. Lordship will keep the matter in the list. Let it run in the list whenever the matter is
What
taken up.
further order?
But I have also, this is the order of injunction which your lordship has passed. My lord, I have also prayed for security to be furnished and assets to be, affidavit of assets to be filed. But in view of the subsequent events, my lordship has seen the newspaper report. But I do not know when the defendant will come out and who is now handling the affairs or the assets of the defendant, since he's not there. That is why, my lord, some further protection may be required. I'll press for that. If your lordship kindly keeps the matter in the list,
This is a sole
whenever it's
decree.
taken.
On the earlier questions,
Mention that after the notice will see to.
But in the meantime, my lord, my lord, I understand, my lord, some further protection may be required. This defendant is a sole defendant, it's an individual. But that is the whole problem.
It is a partnership form, my lord. Now, my lord,
Maybe
the suit has been brought
let them
against one
prove
of the defendant, one of the partners.
2 weeks. Interim order is extended. Interim order extended till 6 up to 8 weeks हो गया ना. आज कितना तारीख है? 17, 18, 18. Extended till 23rd of September 2025 or until further order, whichever is earlier. The counsel for the plaintiff submitted. The plaintiff will press for further orders. Let the matter remain in the list.
My lord, I'm grateful, my lord.
Lordship.
Lordship, keep the report, my lord, lordship's record.
Take. My lord, may I take a leave to mention a matter, my lord. In this matter, my lord, the witness action has been fixed on the 24th July, my lord. This was the change brief, my lord, and subsequently it has been discovered when the original document is not traceable. In this matter, my lord, even the original document inspection has been given to the defendant. Defendant have taken the inspection, but while changing the brief, my lord.
Which matter? Which was the other side?
My lord, I will inform you, my lord. This is the AK Singh, my lord.
You mentioned tomorrow morning.
My lord, tomorrow is holy.
Monday. 24th. When the matter is fixed.
One matter is, my lord, fixed on 24th and one is, my lord, 22, my lord.
2 matters are there.
2 matters.
Both. So why you are not coming with the evidence?
My lord, evidence is my ready, my lord, but document is in one matter, my lord, only 1-2 document is missing, my lord. Other documents are available, and in another matter, no documents is available, my lord.
So what can be done? Why you not mentioning the why you not issued the notice?
My lord, I mentioned same manner, Monday with notice, my lord.
Monday.
Lordship, may I have your kind leave? My interim order is expiring today. Lordship, I'm mentioning upon notice, this is my last order.
Your Lordship, I'm appearing for the defendant in this matter. Our GA3 was filed and it was heard substantially by your Lordship on 30th January. I'm only praying that your Lordship kindly fixes a date for further arguments.
Lordship, we have no issues. Mr. Menak Bo, senior advocate, was appearing on our behalf. He has started his arguments, so we don't have any issues.
What is the matter?
Lordship, this is a suit for eviction.
Yes. What is the GA3?
It is their GA3.
What is your GA3?
Order 14, Rule 2. It is an application under Order 14, Rule 2.
Order 14?
Rule 2. Rule 2.
Order 14, Rule 2.
Lordship, the application is for formation of preliminary issues. The preliminary issues may be decided first and then.
Yes.
And GA1 is our application.
Learned counsel for the plaintiff prays for extension of the interim order. Police counsel for the defendant submitted. The defendant has filed an application being GA3 of 2025, and the matter was heard at length and paid for fixing a specific date and time. In view of the submission made by the counsel for the parties, let the matter appear on 25th of August, 3:45 p.m. as a specific matter. The interim order is extended till 25th of August 2025 or until further order, whichever is.
Lord, in past over, item number 9, I am for the minor contempt number, alleged contempt number 1.
Next Friday. Next Friday it will be listed.